All right. Ladies and gentlemen, my name's John Fry. I'm a judge here in the 17th Circuit. You're here for a magistrate hearing. This is your hearing immediately subsequent to your arrest, where the court will review the probable cause to ascertain whether or not there is probable cause for the charges as outlined. As you walk up here, everything you say is being recorded, both visually and from an audible standpoint. So you need to understand you're not represented by an attorney, and I'm cautioning you to use great care when you start speaking to the court. If you decide you want to tell me what happened or something like that, I'm not going to stop you, but I guarantee you the Office of the State Attorney is going to use it against you at some point. This is a non-adversarial hearing. It's not desired that you explain to me your defenses or anything of that nature. I'm just going to state a monetary bond if it's applicable, and we're going to go from there. We're going to start with LaQuay Stern. Where is she at? Flowers.
Judge,
Yes.
there is a co-defendant in that case who is on the docket but is not here because we don't have his paperwork. I would ask the court at this time to ask the sheriff to bring him to court so that we can be appointed and that we can invoke his rights.
Counsel, we'll get there shortly. Ms. Stern,
Yes, sir.
did you just hear what I said?
Yes, sir.
Okay. Ms. Stern, my name's John Fry. I'm a judge in the 17th Judicial Circuit. For purpose of this hearing, state a couple questions before we proceed. Is there a monetary bond on this young lady at this point?
My understanding is due to the nature of the crime, it has not been set. There is
Okay.
not a standard bond.
Counsel, I am in a position where I think that the interest of justice requires me in a extreme abundance of caution not to magistrate this individual. You are a very experienced and competent prosecutor, so I'm asking you a question at this time for the state's position, and then obviously the PD as well, even though they're not appointed. If I was to roll this case until tomorrow morning for the magistrate judge to set a bond, to your knowledge, would that violate any statutes at this time?
Judge, in good faith, I can tell you it would not, because the state is going to inform the court at this time that we have every intention of filing a detention motion.
Okay.
So that these individuals not get any bond. And per statute, that entitles the state up to 3 days to get the motion to the court and have it heard. So we're putting the court on notice that we can plan on filing those motions.
All right, Ms. Stern, I just would like you to listen to me and then answer my questions yes or no. I assure you that I'm not going to ask you any questions that would put you in peril. Do you understand?
Sir.
Okay. Ms. Stern, at this time, in an abundance of caution, under my obligations as a judge in the great state of Florida, I am going to recuse myself from this hearing. In conjunction with that, I am going to roll this hearing until tomorrow morning. I am going to order that you be detained until such time as a neutral magistrate can look at this and make a decision on what to do. Do you understand what I have just said?
Yes, sir.
Ma'am, have you been fed at this time? Have you been given food, things of that nature?
Yes, sir.
Okay, fair enough. All right, I'm going to ask as a friend of the court, the great Office of the Public Defender, if they would like to say anything at this time.
We have been appointed.
You have been
I got
appointed.
this.
All right.
Judge, at this time, the Public Defender's Office, having been appointed to represent Ms. Stern, would invoke her right to remain silent. Would ask the court to advise law enforcement and the prosecutor's office that she has no desire to speak to anyone from law enforcement about this or any other matter, and that if they wish to speak to her, they should first contact her attorney through the Public Defender's Office.
Detective, your name?
L-I-B-M-A-N, sir.
Detective Livin, good morning, welcome. The Office of the Public Defender has advised you they represent her and that they are asking, and I am instructing you to have no contact with her, at least prior to notification. Again, you have a very experienced prosecutor, so I'm sure we'll obey the law.
We'll convey that to the other investigators also.
I do have something to add.
Go ahead.
Wait,
All right.
The Office of Public Defender is objecting to her not being able to report within 24 hours. She does have a bond on the accessory after the fact by statute. Although, I understand that the state has a good faith motion. The motion is not before the court right now. And as to the charge of escape, there's no probable cause because under statute 944.40, it starts with any prisoner confined. And she was not a prisoner confined, so this charge is not applicable to her and has no ground of probable cause. For that reason, she should not be able to be held on a charge that is not applicable to her and should be able to be released in post bond until which time the state files a motion to do otherwise. So it's violating her rights to due process right now and she should be able to get out right now.
So noted. This matter is reset until 9 o'clock tomorrow morning. State.
Judge, if I may just put on the record so there's no confusion, pursuant to Rule of Criminal Procedure 3.132, pretrial detention, it states if a motion is not filed at the time a magistrate, the judicial officer may inquire whether the state intends to file a motion for pretrial detention, and if so, grant the state no more than 3 days to file a motion under this subdivision. So that's what we are operating under.
And counsel, I'm aware of that. That is why prior to recusing from this case, in order to protect your client's rights, with all due respect, regardless of the allegations and charges, I asked that question. So your objection noted one more time.
So
The
just-
court has recused itself. This matter, hang on for a minute. This matter is reset until tomorrow morning.
Okay, for the record. the
You already
court-
made a record, counsel.
I know, but for the record, the judge has inquired as far as allowing the state to continue to detain her, but then refuses and recuses himself as to my objection to probable cause.
So noted, counsel. Anything further?
No.
All right.
And Judge, you're
There's
gonna
another
call-
IC.
That's correct.
All right. Do we have the name of the other IC?
We do. It's Winston Russell.
Judge, he's here at the main. He is not in the courtroom. He's the gentleman I was asking the court order into the courtroom so that we can at least get as far as we got with the co-defendant.
All right. BSO downtown. Good morning. This is Judge Fry. Can you hear me and come to the camera? Winston who?
Yes, Your Honor.
Good morning. Could you find Winston Russell and have somebody go bring him up here, please, up to you?
I know he is. Yes, sir.
Thank you, Deputy.
Judge, may I approach the state's desk for 1 moment?
You may. Absolutely.
You guys want to hold on to these, or do you want me to? I mean, I get in early because someone from homicide
Okay,
will
fair
come
enough.
down tomorrow. Would you mind if
We can hear you, State.
just so I don't get like? 'cause
Okay,
I'm gonna
they
ask
can
you
hear
questions.
you.
No.
Yeah, unless they're in, yeah, public open courtroom.
Judge, if I may, we don't need to wait for him to go on. Can we do
You
other
ready to go?
cases?
All right.
Yes, sir.
Do me a favor, advise BSO as soon as he's there to let me know. I have a number of people in this courtroom for that hearing. All right.
Thank you, Judge.
Sierra Kovac.
Judge, he's present at the main. We're requesting a photo order with a nurse, and we will be seeking ROR on this case.
All right, so noted. Thank you. State, any input, prior criminal history?
Your Honor, within Broward County, I do not see any prior criminal history.
What's the basis for the ROR, counsel?
Judge, Ms. Kovac's been living here for 3 years. She has a 3-month-old child at home. She is currently on maternity leave. She does not have money to bond herself out at this time. She is a registered voter. She has a place to stay that is separate and apart from the alleged victim. Judge, I'm going to ask the court to read between the lines, and when I argue that this did not happen in a vacuum, there are extenuating circumstances that would apply, not necessarily in this courtroom, but further down the road. It is her her first arrest, and we will be requesting permission for third-party contact relating to the exchange of the child for visitation and purposes like that.
State, anything you dispute to what was just said,
Your
other
Honor,
than the read between the lines part?
Your Honor, I would just be objecting to any contact with the victim just based on the fact that it looks like there were actually injuries observed by the officer and that it is so close in time.
BSO, pretrial, your thoughts? Misdemeanor DV, no prior criminal history.
No, she has no adult charges.
All right. We're going to release the defendant on pretrial. It'll be telephonic pretrial. I'm going to order no contact with the alleged victim. Do you understand that, ma'am?
Yes, sir.
As it pertains to the child, that's not a matter that you all are going to fight about, but you have a third party that can reach out and coordinate visitation with the child. Is that correct?
Yes, sir.
All right. And you're to have no contact of any kind with Kamisha Brown. Is that correct?
Who?
All right, hang on.
Your Honor, it looks like the
It
victim
looks
is
like-
David.
David, you know who David is?
David's the father of my child.
Okay, you're to have no contact with him directly. Do you understand that?
Yes, sir.
All right, anything else?
No, sir.
All right, thank you.
We won't need that photo order now, Justice.
You don't need that photo order now? All right.
No, sir. You need to go here before noon on Monday.
Jessica Haynes, Jessica Haynes.
I have family here on that church.
All right.
Judge, that's a Paul Ryan facility.
Ms. Haynes, good morning to you.
Good morning.
All right, who are you, sir?
Her stepfather, her mother's stepdad went to the rescue.
Okay, your name?
Avery and
All right. State, does she have any prior criminal history to your knowledge?
Your Honor, not in Broward County.
Does she have another place that she can live other than in conjunction with her grandmother?
my house.
Who are you to her, ma'am?
Husband.
Or sir? Husband?
Yes.
Okay. Where do you live, sir?
I live in Pompano.
Okay. And are you the grandmother or you're the mother?
I'm the mother.
Good morning to you.
Good morning.
Any prior criminal history, State?
No, Your Honor.
All right, Jessica, you are to have no contact with your grandmother. Do you understand that? All right, you'll be sitting in jail, no bond if you do. You understand my threat? You're going to listen to me, right?
I think our mic's off.
And you're going to help me with that, right?
Yes, yes.
All right, I'm going to make her bond $500.
Your Honor, if I can address public comments.
You can, go ahead.
How would I be able to get my belongings from her house?
Stop for 1 minute. Go ahead. Do you represent?
I assume.
Okay. What would you like me to know?
Your Honor, in this, one, it looks and appears to be mutual combat.
Okay.
Two, she stated she never intended to hit anyone, that she threw it, and that the police report itself says that it would have struck her had not been pushed out of the way. So there was no actual touching or striking in this, and this charge cannot be sustained.
And Your Honor, I would just bring your attention to the first paragraph that says incident, where it says that she actually spit in the victim's face. That would be battery right there, as well as actually attacking her.
Spitting in face is not touching. It's not touching some exterior or some
Yes, it
part
is.
attached to her. It is an assault, possibly, but that is not the charge that's being brought right now, and there's no probable cause for battery.
Thank you, counsel. Ma'am, what was your question?
I just wanted to know how would I be able to get my belongings from her home?
Your
And
husband, your mother, and your stepfather, I'm sure would assist with that, correct?
Yes.
You're
Yes,
not to
sir.
go there. Do you understand? All right. Court finds probable cause that's bond in the amount of $500.
Is this spit in Sharon's face, Your Honor, but it's not
Counsel, we're
established,
moving on.
it's not established that it was actually touched or hit, spit forward.
Elia Baker. Elia Baker.
Main jail, Judge.
Thank you. Prior criminal history?
Your Honor, I don't see any prior criminal history, but I do see a pending criminal mischief felony case that has been filed.
What kind of bond are you looking for on this?
Your Honor, it looks like this is actually a punishable by life offense for the burglary with a battery. The state would be asking that she be held no bond at this time, that it be set in front of her normal judge, and that it be set for an Arthur hearing.
I'm sorry, what was the state argument?
That should be held at this time and placed before her normal judge for an Arthur hearing.
Why? The argument.
There's a first-degree felony charge for the burglary with assault or battery. That's punishable by life.
Yes, but it's to a conveyance, and that she has the entitlement to have a bond set this time, not to be held in no bond.
Do you have case law that supports the fact that you can't do a burglary with a battery there and in a vehicle? I mean, I was a defense attorney for a number of years, and I seem to remember going to some Arthur hearings on these types of cases. I always prevailed, but preliminarily.
And Your Honor, it's our position that burglary, whether it's a home or a conveyance, that it would still apply if as long as it's a burglary with a battery or an assault.
Statute says, counsel. When can we get her in front of a division judge?
Judge, the public defender can contact the JA and have it set on the docket, but I know normally for domestic violence, if it's on file, they don't put it on the docket until it's filed.
And this would be in front of Judge Cohen?
Yes, Judge.
Does the PD represent at this time?
Judge, she appears to qualify. She has filled out an application.
All right, at this time, I'm going to appoint you. I'm going to specifically instruct you or one of your peers in your esteemed office to contact Judge Cohen, and let's see if we can get this on the docket early next week. I am going to remand the defendant no bond. Again, this boils back down to our discussion yesterday, which is the statute's the statute, and I'm obligated at this point to obey it. But I do think that in light of the information I have, it is worthy of an expedited hearing in front of Judge Cohen. So I'm going to order you to coordinate that as quickly as possible. Fair enough?
Roger that.
All right. Count one, $500. In the event it's changed, there's to be no victim contact.
Your Honor, count one is the burglary with battery.
Count two. All right, Patrick Lamage.
And Judge, we'll need a Creole interpreter for Mr. Lamont.
Do we have a Creole interpreter? Well, that's going to be a problem. What do we do if we don't have a Creole interpreter? Sir, do you speak any English?
He does, Judge.
I'm trying.
Okay, good. Mr. Lamage, you're charged with one count of domestic violence touch strike battery, which means physical contact that wasn't consensual. Do you understand that? Okay. Mute it for a minute. Try and convey to him what I said.
Judge, he understands the charge.
Okay, thank you very much for your help. State any priors.
Your Honor, I don't see any priors in Broward County.
Counsel, does he have someplace else he can go?
Judge, the alleged victim apparently lives in Immokalee. Mr. Lamage does have a job. He works at Walmart. He does support his child. I would argue that the touching in this case was de minimis, and I would ask for the court to consider ROR or pretrial standard.
And Your Honor, according to the probable cause affidavit, there were actual injuries that were observed, such as minor swelling to the right cheek.
All right, you're to have no contact with Ellie Darling. Do you understand that? No talking, no phone. You can't talk with the individual. Do you understand that?
Yes, Judge.
I'm going to set the defendant's bond at $500. No victim contact. Anything further on this?
Never.
All right, good luck to you, sir.
Nothing further here, Judge. All right, phone call. Down the middle.
Jeremy Bello. Jeremy Bello. Have we got the other
He is
individual on
present
the
at the
escape?
main, Judge. Sorry?
Have you got him, deputy?
That's
Yes.
him.
Yes.
All right, let's bring him up.
Come on. One moment, Judge, if I may.
You may.
Pages
60, apparently. I don't think we have any paperwork on him. Yes, absolutely. Thank you. Say again. Imagine, I mean, no matter what it was, if I was charged with loitering on the beach, if I was in county jail, I wouldn't have been sleeping overnight either.
Judge, Mr. Russell has indicated that he intends to sign up to public defender. I assume he's going to be eligible. I'd ask the court to appoint us at this time.
So ordered.
Thank you. Judge, at this time, I would invoke Mr. Russell's right to remain silent, advise the court that, ask the court to advise law enforcement that he does not wish to speak to law enforcement about this or any other matter, and that if they wish to speak to him, they should first contact his attorney through the public defender's office.
So noted, Deputy.
Thank you.
Will relay that to the appropriate people at BSO, correct? Yes, sir. All right, and this is Winston Russell, correct?
Yes, sir.
Good morning, Mr. Russell. Okay, at this time, in an abundance of caution, the court being John Fry, is going to recuse himself off of this case. Any of the number of reasons, the one that immediately comes to mind is I don't even have any paperwork on this case. But in an abundance of caution, I'm going to reset this for magistrate tomorrow morning. State, are you advising me once again, as in the other case, that it's your intent to file various paperwork?
Yes, good morning, Judge Laney Bandel. On behalf of the state, we do intend to file that paperwork, the pretrial detention motion.
Are you renewing your objections?
I am, and I'd like to make the record for it.
Okay, go ahead.
Thank you, Your Honor. He's being charged with 2 counts of two different things. The accessory after the fact has a $5,000 bond, which he should be able to post now, and that the first one, the escape, the statute is 944.40, any prisoner confined. Since he was not confined, there's no probable cause to hold him on this, and so the state's motion to hold him on that, he has the right to have 24 hours to have the probable cause addressed, and because there is no probable cause to hold him on this count, he should be able to get out right now.
Anything else?
No.
Tomorrow morning, folks. Good
Thank
luck,
you.
young man. BSO is aware that they're not to ask him any questions, counsel. I apologize for making you drive all the way down here for this.
Thank you, Judge.
Take care. All right, you ready to proceed? Excellent work, by the way. You're doing a great job advocating for your client. Jeremy Bello. Jeremy Bello. Good morning, Mr. Bello. You're charged with 1 count of touch strike battery, domestic violence.
And Judge, we're going to be seeking ROR in this case as well.
Where's he gonna go, assuming that I was to entertain that? Does he live with Dad?
He'll be living with an aunt if he is released.
Where is the aunt, just because I need to know?
Pembroke Pines?
So in Broward County? State any prior history on Jeremy?
Non-Broward County, Your Honor.
BSO, I'm gonna order him placed on pretrial. I'm gonna release him on his own recognizance with the exception of pretrial. And you're to have no contact with your father. Do you understand me, young man?
Yes, Your Honor.
All right, and I want to caution, say, ma'am?
It appears as if he might have a pending case in Massachusetts. How long have you been in Florida? It appears based on the information we have 1 month at residency, and it appears as if Mr. Bello is actually from Massachusetts, not Florida. So based on that information, it appears as if technically he has no ties to the community, and he's currently homeless, based on the information he gave to the interviewer from pretrial release last night.
Counsel?
Judge, Mr. Bello relocated here from Lawrence, Mass. About a month ago. It was his intent to enroll in Full Sail University and study business. He has since changed his mind. He's now going to try to get into the United States Air Force. He is working already. He has a job at Florida Tropical Landscaping. He does have family other than his father. His aunts and his cousins both live here. And he will be staying with the aunt while he is out on bond in this case. It's his understanding that the issue in Mass was a misdemeanor and that it had been resolved before he left.
Sure.
If he's being released on pretrial release, he had to have an address to verify before he'd even be able to get out anyway, so.
Not if the court is ROR.
Not if I do it that way.
Judge is RORing him, and based on his information, he's homeless. Also, the fact that the PD just indicated he came to Florida to go to Fort Sill University. To the best of my knowledge, Fort Sill is in Orlando, not even Broward County.
Right. He changed his mind, ma'am. He's now going to
Can I
try
hop
to
in
enlist
here
the
for a
United States
second,
Air
Wayne?
Force.
Ready? All right, here we go. All right, the defendant's going to be placed on pretrial release upon verification with the aunt that the aunt will allow him to stay at the aunt's residence. Pending confirmation that he is going to stay at the aunt's residence, he will not be released. So Dale, we need to get that information on where the aunt's information from him.
Name, number, and address.
Name, number, and address apparently, and if you can call over with that information when we have a break.
Because will you be setting a bond pending verification from pretrial?
I'm going to set his bond at $500. Wayne, I'm going to set his bond at $500. If he's unable to post that bond and desires to participate in pretrial, we're going to need him to produce that information. So that way he has two options.
Judge, we're going to need a phone order
So ordered.
so that he can get the phone number of the aunt and get her address for the.
And he's to have no contact with Arias Bell. Do you understand that?
Yes, sir.
All right, good luck to you, young man.
Thank you.
Chong Yo Lee. Mr. Lee, good morning to you, sir. All right, state any prior criminal history.
Your Honor, I don't see any prior criminal history in Broward County.
Do we know where the son lives, Wayne?
Judge, the son has returned to Tampa where he lives.
All right,
And I would argue, Judge, that there's no probable cause in this case. If you read the probable cause affidavit,
the son hit the father
listen.
first.
Right, and my understanding, primary aggressor is the person who starts it. He didn't start it, so I would
And
argue
I
that.
understand your angst, but I think there becomes a time where he had an opportunity not to continue it for terms of probable cause, which is what I'm reading right now. You want to hop in on this too? Yeah, sure, go for it.
There is no duty to retrieve the
Understand that. And I could make an argument as well, but I don't have to. So the court does find probable cause. Now, Dad, let me explain something to you. Open it up for me, Wayne, so I can talk to him. First of all, good morning to you. I'm sorry to meet you like this.
Yeah, good morning.
Your son is in Orlando or has gone back to Orlando, correct?
No, he lives in Tampa.
In Tampa, I'm sorry. When I let you out, you're going to go back to your house. But in conjunction with letting you out, you're not to have any contact with your son. Do you understand that?
Yes, sir.
So what I see happen and what your attorney to your left and this attorney in the state sees all the time is we let people out on bond and we say they can't talk to each other, and then they do talk to each other, and then all of a sudden somebody's calling the police again and there's no contact order and people going to jail again. You understand what I'm saying?
Yes, sir.
So you can't have any contact with him. So I'm going to release you on a monetary bond. I'm going to let you go back to your house, but your son can't come to your house. Do you understand that?
Yes, sir.
All right, and if he does come to your house, you need to leave the door locked and call the police. Do you understand that?
Yes.
All right. Wayne, if you could go over that with him for a minute or so, I'd appreciate it, just so he understands and you're confident he understands, because I really don't want to see him back again as a result of this. All right.
Yes, sir.
State, what are you looking for as far as a monetary bond?
Your Honor, the state will be asking for a $500 bond.
All right. Sir, I'm going to set your bond at $500. I'm going to order no contact with the victim in this case, that being your son. Do you understand that?
Yes, sir.
All right, sir, I wish you the best of luck.
Thank you.
Thank you, Judge.
Christopher Bellinger. Good morning, Mr. Bellinger. Court finds probable cause you're to have no victim contact with Justin Garcia. Do you recognize that name, sir? All right.
Your Honor, the victim is a Craig Bresnahan.
Oh, I'm sorry, I got the wrong name. With Craig Bresnahan. Craig Bresnahan, I don't want you to have any contact with him. Prior criminal history.
Your Honor, for Mr. Bellinger, I do see a prior adjudication for a DUI, but that is the only other criminal history I see in Broward County.
All right.
For the record, Judge, Mr. No, I'm sorry, never.
Bellinger.
Strike that.
All right.
He's 26-year resident of South Florida. His mother lives here as well. He's a volunteer at the Moose Lodge. He's been there doing that for the past 7 years. He is currently receiving SSI. He is a registered voter and does have a place to stay that is separate from the alleged victim while this is pending.
All right, sir, I need to caution you, and you just heard me say this. I don't want you to have any contact with the alleged victim. Do you understand that?
Yes.
Otherwise, you'll be back at the sheriff's bed and breakfast real fast, and I'm sure you don't want to do that again.
No.
All right, then. State, any recommendations on bond?
The state will be asking for a $500 bond.
All right, I'm going to set bond an amount of $500. I'm going to have no victim contact. If you and this victim reside in the same residence, I'm not saying you do, but if you do, you're not to go back to that residence without law enforcement. Do you understand me, sir?
Yeah.
All right, good luck to you, young man. Brendan Olivero.
Mr. Olivero is present, the main judge. He has declined the services of the public defender. He has said he intends to hire Larry Meltzer to represent him.
Okay, outstanding.
Good morning, sir.
Good morning to you. Sir, I'm asking you not to give you a hard time, but do you know who Christine Hill is?
She's my girlfriend.
Okay, you're not to have any contact with her until a further order of the court. Do you understand that?
Yes, sir, I do.
All right, as to count one, I'm going to set your bond at $1,000. Count two, $500. Count three, $500. And count four, $1,000. So it's $1,000 on the battery, $500 on the cannabis, $500 on the paraphernalia, $1,000 on the resisting. So your cumulative bond is $3,000. If you live with this young lady, you have no contact with her. Do you understand me? Even if you don't live with her, don't have any contact with her, okay?
Okay.
No
Good
problem.
luck to you, young man.
Thank you.
Sir, go see him.
Existing one that he did raise the bond.
So noted.
Brandon?
Thank you. Touch strike, Brandon Stanley, Brandon Stanley. Good morning, folks, all three of you.
Yes, good morning.
I'm sorry to meet you like this, I truly am. Whom are you?
I'm his mother,
Mother, what's your name, Mom?
Andrea Jefferson.
Andrea. And whom are you?
I'm his auntie, and I'm also a teacher, and work with juvenile students. And I just wanted to say that he's not.
You're his aunt?
Yeah, I'm his aunt. Yes.
All right, hang on for 1 second. All right, we're going to be back on the record. We didn't talk about the case. Who are you, ma'am?
I'm Austin's aunt,
Your name?
Clara.
Good morning, Clara. All right, so are you aware of what he's accused of doing?
I am.
Okay. State any priors.
Your Honor, for Mr. Stanley, I do not see any priors in Broward County.
Mom, to your knowledge, does he have prior criminals?
No, he doesn't.
Okay.
Would y'all like to go outside?
Were you present when this happened?
I was not, and it's sibling,
I
my
got 4
daughter-
kids, I get it.
Yes, my daughter, she antagonizes all of us now, so.
Okay.
And he's
I have a
mild,
kid
man,
like
I'm
that,
surprised
too.
she wasn't taken away, because she's the one that, she's something else, point blank period. She is.
How old is he?
Brandon is 23.
All right, I guess here's my question. One, he has a statutory right to a bond. Don't misunderstand me. But I have a whole bunch of different jobs. I'm wearing like 12 hats at once and trying not to put them all together.
Right,
And one of my concerns is for your sister, or for your daughter.
right.
All right, and that she is safe. How old is your daughter without telling me her name?
She's 20.
20. Does she live at the house?
She does.
So, as it stands right now, the paperwork indicates to me that he is potentially, at least a reasonable, prudent belief, the aggressor in this, because no matter how much she cranks him up,
She cranks us all up.
how much she
Yes.
cranks everybody up, you still can't resort to
I
physical
agree.
violence.
We definitely agree.
So, from my background and experience, I've been doing variations of this for 30 years. Now, not only is he mad at her for doing whatever she did, he's going to be mad at her because he got to spend the night at the sheriff's office, and it probably wasn't an enjoyable experience.
It wasn't.
So, one of my jobs is to make sure everybody's safe.
Right.
Where is he going to go if I let him out?
He's welcome at either my house or my sister's house.
And where do you live? What city?
Both Miramar.
Miramar. Okay. Do you represent PD? Wayne, are you representing or no?
Judge, he has signed up the public defender, and we believe he is eligible for our service.
All right, the court's going to appoint. State any input on this?
No, Your Honor.
Because a good job record,
Yeah.
his employer has all good things to say about him.
I
Not
mean
excusing
this
his-
with the most respect.
not excusing his,
Yeah, no, ma'am, I understand that. I've stood where you've stood before for family members. Before I was a judge, I want to be abundantly clear since this is recorded. One of the things that I consider, and PD, I guess you can move to recuse me on this if you want after I say it, although I don't think you will, is I'd like him to know this is a little bit serious. And I also like his family member to help me make sure that he stays out of trouble. So I think what I'm going to do is I'm going to order a $250 cash bond, which means you all can literally walk right over there to the main jail and pay the $250 and he'll be out tonight. It's a very small bond based upon what you guys are telling me, but it'll also give you all a little bit of incentive and a little bit of authority to tell him that he needs to stay away from his sister till we sort this out. So I'm not doing it as a punishment, I'm doing it to motivate him so we never have to see him again. Does that work for you? You all right with that, PD? They're going to
well-
pay the bond now.
I appreciate it, Judge. I would just argue, because it's my job, I
I'm fine
believe
with
there's
that.
case law, there's case law that the court does not have the ability to set a particular type of bond. You can only set a monetary or a bond
Oh, yeah, no,
amount.
all right. It doesn't have to be cash. You can use a credit card. I don't know. You can use Canadian money if they take it. I don't care. But if that's your argument, Wayne, that's not what I meant.
That's all I had.
Yeah. You want to hop in here?
I just want to briefly comment.
Sure, go for it.
Priscilla was very uncooperative. She refused rescue, refused to have pictures taken, and refused to give a statement.
That has nothing to do with probable cause, with all due respect. That has to do with the state's ability to successfully prosecute.
Okay, it's just de minimis. I mean, pushed her, causing her to fall.
Understand that. And I don't know where I draw the line in those situations, but I assure you it's not there. His bond's going to be $250. You literally, Robert, if you could tell these nice people where to go. I mean, literally, you're going to make 2 turns and you'll get there. And now I want to tell you, BSO is very busy.
Okay.
From my experience, I was an attorney for a long time before this. My clients generally got out at 3 in the morning.
Okay.
So I can't tell you he'll be out in 2 or 3 hours.
Okay.
And it's not because BSO's goofing off, don't misunderstand me. They're just very short-staffed.
Understand.
All right. So, young man, your bond's going to be set at $250. I'm going to have you stay at one of your aunt's house. Do you understand me?
Say yes or no, please.
I'm going to order no victim contact until I know otherwise. I think that that's in everybody's best interest. And, Mom, would you agree with me at this point?
Yes.
Yeah, so I don't think there's a downside to that. You can get in front of the judge, assuming the state even files these charges in short order. All right?
Thank you, Judge.
Counsel, I understand that.
Hey.
You raise a very legitimate argument. I'm not buying into it today, not because of the argument, because I have very good jobs. Your job's to advocate for your client. My job's to keep people safe. All right? Good luck, ladies. Again, I'm sorry to meet you like that. Have a good day.
All right, there you go.
Carlo Mariano, I'm sure I mispronounced that.
North Broward, Judge.
Good morning, sir. You're charged with 1 count of misdemeanor touch strike battery. You're to have no contact with Maureen Mariano. I'm sure I mispronounced that as well. I'm sorry. Do you understand?
But I do. Yes, I do.
Okay. State, any prior criminal history?
Not in Broward County, Your Honor.
Sir, where are you going to go if I let you out of jail?
Stay with close family member. It was already arranged prior to this. 32nd Avenue. I'm not sure the number on the house. I was there already and removed myself from the house before any police
Do you have
interaction.
the ability to post a $500 bond, sir?
I believe all my cards have been canceled. Not at this moment. No, I don't.
Other than this is de minimis that if charged as intentionally touched against her will, not struck, grab the victim by both arms.
BSO, if he provides you with the information, can we put him on some form of pretrial?
Your Honor, if you want to RR and pretrial release, that's at your discretion. You'll
State?
supervise them.
I know you'll supervise him, but the thing is, he could go into the wind as soon as he walks out the door in jail, and that causes me. I'm not saying you would. Don't misunderstand me.
Yes, sir.
Notes required.
On the door. Hey, counsel, I heard.
Arrests are not convictions.
I've heard that too before. All right. So, do you know the address of the family member?
I just know that I made a right on 32nd Avenue. It was right on the water. It was like the west side apartments.
Do you
They're
know
right
a
on there.
phone number?
Yes, I do.
Give it to me.
973-444-4000.
What's the name?
John Shimati.
John Shamati.
Yes, sir.
Hang on for 1 minute. Record. We'll be back on the record. All right, you still there, sir?
Yes, sir, I am.
All right, I just talked to John.
Yes.
And we have a physical address. I'm going to release you on pre-trial. You're going to need to get some paperwork. How do we get him that paperwork? BSO, do you have the pre-trial form?
Right here.
Outstanding. All right, read that, understand it, live by it. And Carlo, look at me.
Yes, sir.
Stay away from your wife.
Easily done. It will be done, sir.
Stop.
Understood.
Just don't say anything else. Just stay away from her. I'm going to let you out on pre-trial. You should be out in about 8 hours, sir. Juan Malqui. Good morning, Juan.
Good morning.
All right,
Judge, we'll need a Spanish interpreter for Mr.
Spanish
Malfi.
interpreter. I see her right there. Senor Malqui. Buenos dias, senor.
Buenos días, ¿cómo le va?
Buenos días, señor.
All right, this
Buenos
young
días.
lady's going to translate from English to Spanish and Spanish to English for us, okay?
Esta es la intérprete y le va a interpretar del inglés al español y del español al inglés.
You swear, Anna, affirm,
Gracias.
translate English, Spanish, Spanish to English to the best of your ability.
I will, Your Honor. Luis Angela Lopez, LOPEC, certified Spanish interpreter for the courthouse.
It's good to see you again.
Good to see you too, Your Honor.
All right, the court does find probable cause. State any prior criminal history.
La corte encuentra motivo fundado para detenerlo.
Your Honor, no prior criminal history in Broward County.
Sir, do you understand what you're charged with? I'm not asking for comments.
It's-
Wait and be ready to hit that button and he starts talking.
Señor, ¿usted sabe de qué lo están acusando y no diga nada acerca del caso? ¿Usted comprende de qué lo están acusando?
Sí.
Yes.
Okay. So I'm not going to read it out loud to you. It's important to me that you understand because your English might not be that good. That doesn't mean you don't have the right to understand.
Le voy a... no voy a leer las acusaciones que tienen en contra suya, pero es importante que yo sepa que usted entiende de qué lo están acusando, porque a lo mejor usted no entiende muy bien el inglés.
No, sí yo sé lo que me están acusando.
Yes,
¿Por
I
qué me
know
están
what I'm
acusando?
being charged of.
Counsel, any arguments?
Pregunta a los abogados si hay algún argumento. Dicen que no.
And, Your Honor, I did not get an opportunity to interview my client. If the court wishes to inquire as to his ties to the community, I would have no objection.
So noted. The defendant's bond set in the amount of $25,000. You have no contact with the victim.
$25,000, Your Honor.
25,000.
El señor abogado allá presente le ha dicho al señor juez que él no ha tenido la oportunidad de hacerle preguntas en cuanto a los vínculos que usted pueda tener con la comunidad debido al lenguaje. El señor juez dice que toma ese argumento del abogado de la defensa en consideración y que le impone una fianza de $25,000 y no debe tener contacto o comunicación con la víctima.
Señor, buena suerte. All right, George
¿Tienes
Messick.
preguntas?
Señor, ¿tiene
No.
preguntas?
Sí, no le entendí. ¿Cuánto es de la fianza?
Yes, I did understand. How much was the bond?
$25,000.
$25,000.
¿Eso es lo que se tiene que pagar o hay un descuento ahí?
Is that what I have to pay or is there a discount in that?
No discount that I'm aware of. That's your bond, sir.
No hay descuento que yo sepa. Esa es la fianza que yo le he impuesto.
Bueno, gracias.
Momento, señor.
All right, hang on.
Señor.
Have him stick around. Sir, let me explain something to you.
Permítame le explico algo, señor.
I've been to the main jail before, and I know they have those things with bond numbers on them.
Yo he estado en la cárcel principal donde usted está y yo sé que tienen unos avisos grandes donde dicen los números de teléfono de unos fiancistas.
You have the right to contact them and ask or them any questions you may have. Wayne, are you appointed or no?
Yes, Judge.
Okay.
No
Dice
le-
el señor juez que usted tiene derecho a llamar a esas entidades o esas personas y hacerles preguntas y pregunta al abogado defensor si lo han asignado a su caso y dice que sí.
Bueno, voy a conversar con la hermana y voy a ver qué es lo que hago.
Thank you, sir. Have a
Okay,
good
I
day.
am going to talk to my sister and see what I can do. Buena suerte,
Y,
señor.
bueno, ¿puedo llamar teléfono?
May I call that phone?
They'll help you with that at the jail.
Ellos le van a ayudar allá en la cárcel con esa situación.
Bueno, gracias.
Madam Interpreter, if you would indulge me, sir, could you please ask my client whether he knows his sister's number, or does he need to get to his phone so that he can get it?
Señor Malky, ¿usted conoce el número de teléfono de su hermana de memoria o necesita que le permitan entrar en el teléfono para poder sacar el número?
Tengo el número aquí.
I have the number right here.
Thank you.
Gracias.
Gracias, señor.
Sir, again, one more time, no contact with the victim.
Señor, de nuevo, no puede tener contacto o comunicación con la víctima.
Bueno, gracias.
Okay, thank you.
Thank you, Judge. George?
You're a student in Judge Schiff's class? Microphone. All right, we'll get to Slobby relatively quickly, and my apologies to you to make you wait, okay? All right, George Messick. Mr. Messick, good morning. As to count one, the court finds probable cause. Your bond, counsel, 1 minute. As to count one, the court finds probable cause. Your bond set in the amount of $10,000. As to count two, the court does not find probable cause. As to count three, the court does find probable cause. As to count four, the court does find probable cause. Is there any additional arguments you want to make, counsel?
There was no probable cause on count two.
That's correct.
I just didn't have any, anything to even argue with, so it's an objection to the due process rights.
I read you this one. This is the one with the strangulation where he stood up. So for the record, counsel, are you withdrawing your argument that I didn't tell you? Okay, just to make sure. All right, as to count one, I do find probable cause. His bond's going to be set in amount of $10,000. Wayne, I don't find probable cause as to the deadly weapon charge. It's not contained in the PC. And State, we've discussed this as well
Yes,
prior
sir.
to him being here. Domestic violence by strangulation, bond $10,000. Culpable negligence as to the child, $1,000. So his cumulative bond is going to be $21,000 at this time. Good luck to you, young man. You're to have absolutely no contact with Vanessa Parker. Without telling me any additional details, you know who Vanessa Parker is, correct?
Yes, sir.
Okay, for your own safety, sir, don't have any contact with her because that'll be an additional charge. Good luck.
And Your Honor, I would also ask for no victim contact with the juveniles that were here as well.
In light of the culpable negligence charge on one count, I think I have the statutory authority to do it. So Jada Missick is... Wayne, I'm going to give you the opportunity to explain any familial things, but I'm not going to ask him any questions about the young child with the same last name as him.
I'm going to move the court to reconsider the bond amount in this case, based on several factors besides the community and the length of time between the alleged crime and his arrest. This is not a custody information. It's not a capias. He's a lifetime resident of Broward County. All of his family lives here. He has been working at McDonald's for the past year. He's in training to become an assistant manager. He does not currently have money to bond himself out. He is supporting 3 children, and his wife,
Wait,
including
stop for 1 minute. Who's his wife? Is this her?
Yes, Judge. They have been
Wait,
residing.
hang on for 1 minute. Just hang on. You know me well enough. Just hang on for 1 minute. State, this incident allegedly occurred in September 2015. The PC is dated September 30th of 2015. Looks like we picked him up last night.
Yes, Your Honor.
Which at a minimum tells me he's had no law enforcement interaction for a year because it's multiple felony counts.
Yes, Your Honor. He does have a history in Broward County, but the newest offense being in 2010.
What do you think we should do, Wayne? I'm not RR.
Judge, I would ask the court to consider lowering the bond to about 10% of what it's currently set at.
Where are you going to stay?
I'm going to stay with a friend of the family or either with my mom.
Does your mom live in Broward County?
Yes, sir.
What city she live in?
She stays in Daniel, but I was going to go stay with my friend in Hollywood.
State thoughts?
Your Honor, I would ask that you keep the bond that you've already established. The facts are serious, and especially the victim being 5 months pregnant and the defendant knowing this, I would ask that you keep the bond in the amount that you've already said.
Your Honor, a year ago, the victim was no longer pregnant because this happened a year ago.
That didn't make sense, but I know what you're trying to say.
Judge, Mr. Missick has been residing with the alleged victim in this case since this occurred as a family. They have 3 children. He's got a 6-month-old child who is fine, a 5-year-old and a 4-year-old.
Is he working now?
He is. He's in training at McDonald's to become an assistant manager. He's been there working there for a year.
Your argument resonates with me. It causes me angst. Here's my solution. You ready?
Yes, sir.
I'm going to let him out, but I'm going to let him out on a GPS.
Yes, sir.
All right, and then we'll put him in, we'll get him in front of Judge Cohen as quickly as possible, because I'm sure the state attorney hasn't worked on this case in the last year. The facts and information may have changed. So, Mr. Missick, I need you to listen to me for 1 second.
Yes,
I'm
sir.
going to instruct the sheriff of Broward County to put an ankle monitor on you.
Okay.
All right. Y'all represented the PD's office or no?
Yes, sir.
At this point, you do? All right.
He's applied. I believe he's eligible.
He qualifies? You think?
I believe so.
All right, I'm going to
Yes, sir.
appoint provisionally. Let's get him in front of Judge Cohen as quickly as possible. You develop whatever you need to do as it pertains to the GPS monitor. I think in light of the facts and information state, again, wearing my many hats, I think justice is better served by knowing where he is versus a monetary bond. So I'm going to release him on pretrial. BSO, I'd like a monitor on him. We're going to need an address in Hollywood where you're at. This is a short-term provision. You'll go in front of the real judge on this case, who is your judge. The real judge. I can say that about Judge Cohen. I appeared in front of him for a long time. He is a real judge. Your attorney, you know, especially if it's the PD's office, some of their best and brightest people work in domestic violence. So they'll work on this real quick for you, all right?
Okay, so no monetary bond, GPS not be level 2,
No
Judge?
monetary bond, GPS level 2. What time do you normally finish work at, George?
I work at night sometimes like very rarely. Sometimes they have me in the morning. It depends on the schedule.
Okay, and you know the schedule in advance, right?
Yeah, I'll let you know in advance, yeah.
Right, you let pretrial know.
Yeah, I'll let them know.
You're going to let pretrial know. You're also going to give the address before you get out where you're going to. All right,
Okay,
and
no
you
problem.
need to understand that if you're out, that it's from McDonald's with
And
a whole
back
bunch
home.
of Happy Meals to wherever you're staying. And that would be the extent of your travels other than see your attorney until we can sort this out, okay?
No problem, sir.
That's level 2, Your Honor.
Yes.
And Your Honor, I was just informed that he is a recent releasee from prison, looks like within the last 6 months.
January of last year, that's why.
It's been a year.
He's not on parole or anything like that.
I done passed my parole.
Wait a minute.
Judge, if he was released
Hang
from
on for a
prison
minute. Wait,
6 months ago,
this is not my first day at the rodeo. How was he released from prison with an open felony count? There's got to be an error there somewhere.
No, Your Honor, he was released from state prison January 17th of 2015, and then months later is when he picked up this new alleged.
So it wasn't this January state.
No.
Understood, Your Honor.
All right, does that answer your question, Wayne? Yeah, good try.
Judge, it's Dale, by the way.
All right, I'm sorry, Dale. All right, moving on. Did we do Carol Thomas yet?
No, Your Honor. North Broward.
All right, Ms. Thomas, you have good morning to you. You have an active no bond warrant at this time. Thank you, ma'am. Brittany Foster.
Main jail.
Main jail. Ms. Foster, you have an active no bond warrant. Good luck to you, ma'am. Jennifer Riggs.
Judge, she's present at the main. We're going to be asking for pretrial release with a BARC component.
Dave Priors.
For Ms. Riggs, Your Honor, I don't see any any prior arrests or convictions in Broward County.
How old are you, young lady?
26.
Have you been arrested before and convicted?
No, sir, not convicted.
They any objection to putting her on pretrial and getting her some help?
No, Your Honor.
BSO might want to say something here. Go ahead.
Yeah, we were unable to verify her address this morning. I made a couple calls to her mom, and all my calls were forwarded to voicemail. I left messages and no one returned my call as of 2:15 when I left the office.
Wayne, I'm going to post her bond on count 1 in the amount of $50, and count 2, I'm going to make her bond $250. That's a cumulative $300. I am going to authorize her release on pretrial with a BARC component, but we're going to have somebody get a hold of pretrial. You understand what I'm saying?
Yes, sir.
So I don't want her to sit in jail because we can't make a connection here. Her bond's going to be $300, but if she can do pretrial, I'll authorize it. Fair enough?
Yes, sir.
Good luck, young lady. No, 50 and 250. 50 on 1, 250 on the felony. All right, let's talk to William Alvarez.
Spanish interpreter, please, Judge.
One more time.
Requesting a Spanish interpreter for Mr. Alvarez.
Before you get out of there, they got to
Buenos días, señor. ¿Cómo está?
Bien, usted.
Ay.
Good, and you?
Aquí somos mejor de otros, pero ahí está. This young lady's going to translate for you from English to Spanish, Spanish to English.
Este intérprete va a interpretar de inglés al español y de español al inglés.
Corey Butler.
Okay. For me.
Sir, your bond is set at $500 for an outstanding warrant. Do you understand that?
La fianza que le imponen es de $500 por una orden que tienen de captura todavía vigente.
Oh. ¿Puede repetir, por favor?
Can you repeat, please?
You want me to do it again, or you just want to repeat what you said?
Yes, yeah. Señor, le han impuesto una fianza de $500 porque tienen una orden de detención en contra suya.
You were charged with one count of petty theft very early this year.
Al comienzo de este año lo acusaron de hurto menos cuantioso.
And you didn't show up in court in July
Y usted no se presentó a la corte en julio
in Hollywood.
Okay.
en la ciudad de Hollywood.
Your bond is $500. Good luck.
La fianza que le imponen es de $500. Buena suerte.
Bueno, ¿tienes preguntas? Ahora no estoy trabajando, entonces.
Right now I'm not working.
Okay.
Sir, your bond's going to be at $500. You were released and you didn't show up at court. That gives me a little angst releasing you again.
La fianza que le imponen es de $500. A usted lo habían dejado en libertad para que se presentara a la corte en julio y usted no lo hizo. Eso me angustia un poco.
Okay. Okay. Gracias.
Well, he's going to have to get transferred downtown.
Corey Butler.
The case is going to have to transfer to a 10A case because he's in custody. He can't go to a satellite because of the aftermath of Deputy Rain being killed. So I have no control over that. That's the clerk's issue. Corey Butler. Good morning, Corey.
Good morning, sir. Judge, Mr. Butler's case is a municipal ordinance charge. I have
read
an
it.
outstanding here.
All right, Corey, I'm going to ask you a bunch of questions. The first question is this. Are you interested in possibly resolving this case today?
Yes, sir, Your Honor.
All right. Are you currently on probation, parole, anything of that nature?
No, sir.
Raise your right hand. You swear and or affirm, tell the truth, the whole truth, nothing but the truth.
Yes, sir.
All right. Tell me your full legal name.
Corey DeSoto Butler.
All right, Mr. Butler, you're charged with a municipal ordinance. It appears to be out of
Hollywood.
Hollywood. Fair enough. You're not on probation, parole, anything of that nature, correct?
No, sir.
Mr. Butler, you understand if you're not a citizen of my beloved United States of America, the entry of this plea could, and for purposes of this discussion, would result in your deportation. Do you understand that?
Yes, sir.
And knowing and understanding the potential consequences as to your ability to stay in the United States of America, you still want to resolve this?
Yes.
You have absolute right to legal representation by the attorney of your choosing. If you couldn't afford an attorney, I'd appoint somebody to represent you. Do you understand that?
Yes.
When the police arrested you, they had a piece of paper, probably gave you a notice to appear. That's a yellow ticket. You understand what I'm saying?
Yes, sir.
And in that, they would have had to lay out basic facts which established the basis for them to believe you're in possession of an alcoholic beverage or a controlled substance. Do you understand that?
Yes, sir.
I don't have that document in front of me. The only document I have is the capias warrant. So by asking me to resolve this, you're telling me that you're okay with me not even looking at the basis of the arrest. You just want to resolve it. Do you understand that?
Yes.
Anybody threatening or forcing you, making you do that?
No, sir.
And you under the influence of anything affecting your ability to understand what's going on here today?
No, sir.
You want to resolve this case?
Yes, sir.
How do you plead?
Guilty.
No contest.
You want a mulligan?
No contest? No contest?
All right. So let's have a tiebreaker because you got 1 and 1. Which one you taking?
No contest.
All right. Withhold court costs. Sir, I find no charge of voluntarily plea entered by the defendant. Knowing and understanding and waiving his rights to counsel, I find you guilty. However, I do withhold adjudication. I'm going to assess court costs in the amount of $293 and close this case out. You'll be out at some point. I'm going to give you what? $78, not even $293. And I'm going to give you 6 months to pay that fine. Good luck, young man.
All right.
Take care. Oscar Lewis.
Mr. Lewis is present at the main jail, Judge. He also is interested in resolving this case. However, I would ask the court if you're interested in resolving, if we could get a withhold of adjudication so it doesn't jeopardize his ability to obtain a license.
I'm with you. I understand what you're saying, but I have a little bit of angst. And the angst is I don't know any of the information associated with this other than what I have, and that's that he had an active warrant and was picked up.
Judge, I believe the state attorney could print out the original arrest report if the court wishes to review that.
And Your Honor, just for the record, there is a currently filed burglary case that is pending for Mr.
He has a
Lewis.
pending burglary charge?
Yes, Your Honor. In 2016.
What was the date of the alleged burglary charge? Because that could be important.
The date I'm seeing according to is, I would believe it's April 12th. But I will check to make sure.
You have a PC, you said?
No, I was mistaken. It's just the police report talking about the warrants.
And I apologize, Your Honor, I'm having
Count
some
one, the
technical
defendant's bond's going to be $250. Count two, the bond's going to be $250. Sir, I'm not doing that to penalize you. I'm actually doing it to make sure that we don't have to do this all over again. Good luck to you.
Judge, thank you, Judge.
Swabby.
Main jail, Judge.
Everton Swabby. All right, Mr. Swabby, there's somebody here that wants to say something. What's your name?
Taisha Mainville.
Taisha Mainville. All right. Miss Mainville, what would you like to tell me?
That basically what the police report is, the pushing and the shoving. I mean, I just had a little scratch. Basically what happened was I heard the police over speaking, and one of the officers was Officer Silas. One of the police officers was telling him what to put inside the police report, which is something that I didn't actually state because I actually reviewed it with Officer Ramos. Me and Everton, we just was having a basic conversation about previous things that happened to our relationship. He got a little rowdy. I was blocking the door so that he won't leave so we can actually talk. So it was like a pushing and shoving. It was nothing very serious. He left and I let him go throughout the door. However, police was called, Lauderhill Police. I didn't call the police. I didn't want to press charges. I didn't want to do pictures. I didn't do a statement because it was really nothing serious. However, I called Everton later on that night because he went by his friend's house to actually go ahead and cool off. I called him, let him know that I think police officers are actually looking for him because they stated that he was going to go ahead and put out AP, whatever it is. However, Everton came back to the home. We met up at Lauderhill Police Department, and we had the police to come out there, and Officer Ramos was like that he just have to call and just take Everton into custody because what the officers, based on the report from that Friday night. So basically that's what happened.
You swear in? Other one.
Oh,
You
I'm
swear,
sorry.
affirm, tell the truth, the whole truth, nothing but the truth?
I swear.
All right. Is everything you just told me true and accurate to the best of your knowledge?
Yes, it is.
And do you want to change anything you just told me?
No, I don't.
State, you want to ask her anything at this time? You can put your hand down, sweetheart.
Yes, Your Honor. Ma'am, are you currently in any fear from the defendant?
No, I'm not. He's
And-
actually great with his child. He's great with me. We just had previous things that kind of interfere with our relationship, and we was actually talking about it. But I don't feel any harm. I don't feel threatened. I mean, we have a child. We've been together for 5 years. We went to high school together, and we're still together, and we're currently engaged.
Has he ever been physical with you before
No.
in regards to an argument?
No.
So, ma'am, if I call Lauderhill Police Department right now, there's no prior responses out there?
I'm sure. I'm positive.
All right. Sorry, I didn't mean to cut you off. Just that's
It's
generally
fine,
a
Your
good
Honor.
question to
And
ask.
I have no further questions besides that.
That, I mean, we have live testimony saying the report is not correctly reflective of what the victim is now testifying to, so it's pretty fatal, probable cause.
I would,
In your opinion, yes.
and I would disagree with that, Your Honor. Obviously, the officer is not here to testify, but he has his written report here. And in fact, it sounds like the witness is saying that a physical act did actually happen.
Oh, yeah.
So, the argument that the state is making is that the hearsay should trump the actual witness's live testimony.
What hearsay? There's a probable cause affidavit submitted by the officer.
Which is hearsay. I mean, it's allowed in probable.
Let me know when you two are done.
It's allowed in this setting, yes, but it's still hearsay. It's not admissible for trial, and since it is hearsay, we have now a live witness testifying that it's not accurate. I don't understand how hearsay can not be fatal.
Anything else?
No.
You want to say anything?
No, Your Honor.
My turn?
Yeah, sure.
I just want to pipe in, Judge. He does have the 1-year-old child that he helps to support. He's been working at Associated Grocers for the past 2 years, and if the court requires, he has a place to stay that is separate and apart from the alleged victim. However, I would ask the court, under these circumstances and the testimony that before the court today, that he be allowed to have contact. And we're asking for ROR.
Prior criminal history.
Your Honor, I don't see any prior criminal history in Broward County.
Where's he going to stay?
With Mom.
Where's Mom live?
You get that?
Yeah.
Lakes?
Alright, the defendant's going to release, the court's going to release the defendant on pretrial release, no monetary bond. You're going to stay with your mom, you're not going to stay with her. Any child contact will be through a third party, your mom maybe. I guess that would be grandma, correct? Do you have a good relationship with his mother?
Yes, I do.
Okay, so I need you to help facilitate his visits with the children and all that sort of stuff. But until we can figure out what's going on here in an abundance of caution,
Okay.
I want you two to stay separated, okay?
Okay.
Now, you need to understand, even if you don't want to prosecute, which is your right, the state gets to make that decision, not you, even though you don't want to participate.
Okay.
Do you understand what I'm saying?
I understand.
The second portion of that is I just ordered that you two are not to have direct physical contact. Do you understand what I'm saying?
I understand.
All right, I'm not threatening you, but if you disobey my order, then he's going to have more problems at a minimum. So please don't put him in that as you're trying to help him out.
Okay.
Get with an attorney, do whatever you all need to do, address this as quickly as you can.
Okay.
All right? Anything further?
Judge, we just want to get a phone number of Mr. Swaby's mother so that pretrial can call and confirm.
Go ahead.
Give it up. Go ahead. Tell him.
My phone number?
Hey, we're going to give it to you privately, Judge.
Okay, no worries. All right.
Thank you.
You are finding probable cause?
Yeah, I am finding probable cause. By her own admission, she said that it was a little altercation and she did get a scratch.
But not intentionally.
Counsel, you make an excellent argument that's not pertinent today. Ryan Lucero. Good morning, Mr. Lucero.
Say good morning to the judge.
All right, this is
For Alan?
All right, the court's reviewed the paperwork. The court does find probable cause. On count 1, your bond set at $250. On count 2, your bond set at $250. Good luck, young man. Christopher Allen.
Main jail judge, Mr. Allen would like to resolve this trespassing charge if he can. Are you Leonard Tompkins? Yes, sir. Okay, you're next.
All right, Mr. Allen, let me explain something to you. I have no problem resolving this case, but I have a little bit of angst. I don't want you to say anything. And the angst is that it appears that you went into a house that wasn't yours. I assume that's because you're homeless. And I assume it's because you want to take a shower. But that's not exactly the way the law reads. And you can't do that. And so I have to assume at this point that you intentionally did something if I'm to resolve your case today. There's also potentially just a whole veritable ton of possible reasons that you wouldn't be charged criminally, but you're potentially looking at me today and saying, hey, you want to resolve that. Is that accurate, sir?
Okay.
All right. You understand you have an absolute right to legal representation by an attorney. You understand you'd be waiving that right today if you were to resolve this case today.
Yes, sir.
State prior criminal history on Christopher Allen.
Yes, Your Honor. There isn't a prior adjudication for driving with the license suspended back in this year, 2016. There's a prior adjudication for an attempted burglary conveyance. There is a prior adjudication for failure to obey a traffic law in 2012. Prior adjudication in 2011 of possession of alprazolam. Prior adjudication for loitering and prowling in 2011 as well. Prior adjudication for robbery, no weapon in 2009.
Mr. Allen, I want to caution you. After you enter a plea, I'm going to ask you what happened here. You're going to have to explain it to me. I'm not promising you how I'm going to resolve this case. Do you understand that?
Yes, sir.
Do you still want to resolve your case today?
Yes, sir.
You understand if you're not a citizen of the United States of America, the entry of this plea is going to result in your deportation.
Yes, sir.
You understand if you're on probation, parole, anything of that nature, anywhere on planet Earth, the entry of this plea is going to violate that. Are you on probation or parole?
Oh, no. No, sir.
How do you plea?
No contest.
Why were you in this house?
I was just trying to take a shower. I mean, it was hot outside. I was trying to clean up. A couple people in the neighborhood told me that they take showers there and shit, so I went and took a shower. And I was there for about 2 minutes, and the cops came.
Have you got a place to go?
Not right now, no.
Have you talked to Salvation Army at all?
Yeah, I'm in the process of getting into a shelter.
Which one?
Christopher, I'm not making fun of your situation, but I'm in the process of winning the lottery. Alright, you're in the process of getting in a shelter doesn't tell me anything. And my concern is you're going to get right back out and you're going to be right back in, and I don't want that. All right, I find you guilty in light of your extensive criminal history. I'm going to give you a withheld adjudication for it costs a year to pay. Have a good day.
Thank you, Judge. You're done. Down the middle.
Good luck, sir. I hope it gets better for you. Leonard Tompkins.
Judge, this is Mr. Tompkins. He is also interested in resolving this misdemeanor possession charge.
One moment, Your Honor.
We would obviously be seeking a withhold so that he can someday get a license.
State priors.
Your Honor, I see a prior adjudication in... These cases go back to 2006. A prior adjudication for possession of cannabis, possession of drug paraphernalia. Prior adjudications from 2005 for battery and criminal mischief. Prior adjudication also from 2005 for possession of cocaine and tampering with evidence.
Nothing since 5?
The most recent case being 2006. And
Mr. Tompkins, raise your right hand. You swear, affirm, tell the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
I'm going to ask you a question right now, and if you lie to me, it's going to be messy. Do you understand me?
Yes, sir.
Put your hand down.
Put your hand down. Where you been since 2006? Have you been in prison?
Yes, sir.
How much
I
of
went
that
to
time
prison.
have you been in prison?
I went 2006, got out 2007, and I went 2008.
When did you get out
I
on
got
that
out.
one?
2010, sir.
So since 2010, you've had no new arrests, is that correct?
Yes, sir.
Anybody threatening or forcing you, making you resolve this case today?
No, sir.
You understand as a result of this plea, if you're on probation, parole, anything of that nature, the entry of this plea will violate your probation or parole.
Yes, sir.
You understand you have absolute right to legal representation by the attorney of your choosing. You're waiving that right to resolve this case today.
Yes, sir.
You understand as a result of this plea, if in fact what you're telling me is inaccurate, you're not going to be able to take this back. You understand that?
Yes, sir.
All right, I do not have a copy of the event report. The only thing I have is a copy of the warrant, so I can't even review the probable cause affidavit to make sure there was probable cause for your arrest. Do you understand?
Yes, sir.
And you're willing to let me do that because you just want to be done with this, correct?
Yes, sir.
You understand if you're not a citizen of the United States of America, the entry of this plea will result in your deportation.
Yes, sir.
No, no, understand all these rights. Do you still desire to resolve this case?
Yes, sir.
How do you plead?
No contest.
Are you under the influence of anything affecting your ability to understand what's going on here today?
No, sir.
Withhold 393. I find no intelligent voluntary waiver of the defendant's rights. He's waiving his right to counsel after full and complete understanding. Good luck, young man. Tony Wells.
Thank you,
Tony
sir.
Wells.
Mr. Wells, the president of the main jail.
Yes, sir.
Despite the obvious holes in the probable cause affidavit, Mr. Wells is interested in resolving this case as well. Elliot?
You want to resolve this case today, sir?
Yes, sir.
Date.
Yes, Your Honor.
And just, if the court is interested, I do not observe any signs of impairment at this time, and I believe he is competent to proceed.
Thank you.
David?
Your Honor, it looks like his most recent adjudication is back in 2003 for possession of cannabis and possession of cocaine.
Tony, you want to resolve this case today?
Yes, sir.
You understand that in reading this, there might be a whole bunch of legal defenses that you can raise to try and get out of this pickle. You understand if you resolve it, you're waiving it.
Yes.
And you want to do that today?
Yes.
All right. Anybody threatening or forcing you, making you do this?
No, sir.
You understand? I've been doing this for 16 years now, Tony. The whole lawyer thing. That's a long time. I started out in the public defender's office. I was an intern there back in the day when they gave me money to come in. Lots changed since then. And that's a very good law office. Some of the best attorneys I've ever met work at the public defender's office. And you're telling them you don't want them to do anything. You just want to resolve this case today and be done with it.
Yes, sir.
All right. You understand if you're not a citizen, you're going to get deported?
Yes, sir.
You understand you're on probation or parole? It would violate your probation and parole if you enter this plea.
Yes, sir.
How do you plead?
No contest.
Is this a $78 one? Withhold $293 in court costs. I'll give you a year to pay for it. Have a good day.
Thank you.
Thank you,
Antonio
Judge.
Elliott. Antonio Elliott.
Judge, he's president of the main judge. It's a municipal ordinance case. If I may speak as a friend of the court?
I'll let you be presumptive like that. Go ahead.
Well, I'm asking permission.
Go ahead.
Mr. Elliott is a head foreman at Allen J. Inc. It's a roofing company. He's been there for a year and 3 months. He has a daughter at home, a 1-year-old that he takes care of. And he also volunteers at Spiritual Church and his Army as a head instructor for this youth program. He's been doing that for the past 15 years. This is a 2011 controlled substance charge, and he is interested in resolving the case.
He's allegedly at the Happy Tails dog park today. All right, prior criminal history.
Your Honor, 2 adjudications in 2007, one for fleeing or attempting to elude a police officer and resisting with violence.
Anything since 11 that you're aware of?
And it was 2007, and no, Your Honor.
All right, Mr. Elliott, you want to resolve this case today?
Yes, sir.
Anybody threatening or forcing you, making you do this?
No, sir.
All right, you heard what I just said about your right to attorney, right?
Yes, sir.
You want to waive that right just to resolve this today?
Yes, sir. I'd love to resolve this.
You understand
I'm not even
it'll be on your record, not a conviction, but it'll be on your record from back then. You understand that?
Yes, sir.
You understand if you're not a citizen of the United States of America, the entry of this plea could result in your deportation.
Yes, sir.
All right, anybody threatening or forcing you, making you do this?
No, sir.
All right, it seems to be from what I'm hearing that you figured it out at some point, and this is just a residual issue. Am I correct?
Yes, sir.
How do you plead?
No contest.
All right, withhold court cost. I'll give you a year to pay the court cost. You'll be out in 5-6 hours, all right?
All right, thank you so much.
Hang on for 1
Thank
second.
you, Judge. All right.
So are you a U.S. citizen?
Yes, sir.
There you go. Thank you. Have a good day.
All right, you too. Thank you.
Ward Crowell. Ward Crowell.
President of the Maine declined, PD Judge.
All right, sir. I find probable cause. Your bond on count one's $1,000. Your bond on count two's $500. Have a
Do you
good
need an
day.
interpreter?
Regine Francois. Regine Francois.
Present at the main jail?
Mr. Francois, your bond's going to be $500. Can you post that bond, sir?
Yes.
All right. Good luck
sir.
to you. On count two, it's not a it's not a criminal infraction. Good luck. Have a good
Seidel?
day. Let's see. Seidel Vilsenor. Seidel Vilsenor.
North Broward.
Where's he at?
North Broward.
Good morning, sir. I do find probable cause on count one. Having said that, I'm going to release you on your own recognizance. City, any objection at this time to me releasing him on his own recognizance? City. Well, we don't know that. City. Hearing no objection, the defendant's released on his own recognizance on count one. You're welcome, sir. Daniel Castellanos. Daniel Castellanos.
And put that on recall for one moment, Judge. This is Mr. Hicks.
Calvin Hicks. Calvin Hicks. Good morning to you, sir.
Good morning.
All right, your bond set at $250. Can you post that bond, sir?
I'll try to find a way to. Judge, he told me he wanted to try to resolve this GW no valid driver's license case from last year. Are you? Sentinel? Yes, sir. Speaking? Yes, sir.
Hang on for 1 second. Let me see if I have a deal.
Thank you, Judge.
Mr. Hicks, you want to resolve this case today?
Yes, sir.
Now, Mr. Hicks, I need to caution you. It would appear facially, before I can take a plea, I have to make sure a plea is justified on the information I have. Do you understand me?
Yes, sir.
All right, so there has to be a basis for it. You're charged with operating a motor vehicle without a valid license from the information I have in front of me. One of the obligations the state of Florida have is to prove that you were put on notice that your license was no longer valid. Do you understand that?
Yes, sir.
I have no idea if they did that or not, and I can't tell definitively if they did that or not. So you're going to waive that defense to resolve this case today. Do you understand that?
Yes, sir.
You still want to do that?
Really not really.
All right, your bond set at $250. Have a great day, sir.
Judge, I don't think he understood I don't think he was answering the question you asked.
Okay. Sir.
Make sure you understand the question he's asking you.
If you resolve this case today, for purposes of the plea only, you're going to be admitting that you were driving a vehicle knowing that you didn't have a valid license. Do you represent him, counsel?
Did you sign us up? That's on y'all. Did you sign up for public defender? Judge,
I'll listen to you. What do you want to tell me?
Operating without a valid driver's license does not have a knowledge requirement. It's not driving while license suspended with knowledge or anything like that. So the knowledge component that you're talking about is not an element of this.
Okay. Don't necessarily know that I agree with you, at least in my division. I'd like them to know about it before they get a ticket for it. So having said that, sir, do you still want to resolve this case today?
No, I just want to pay the $250. You're going to pay the $250 and bond out and fight it? Yeah. All right. Thank you.
All right. Your bond set at $250. Have a great day, sir.
All right. Thank you. Okay, and we found Mr. Castellanos, Judge.
Javon Henry.
I'm sorry.
Medical reset, Your Honor.
Okay, and you want to go back to Daniel Castellanos, correct?
Yes, please.
All right, so you're charged with a municipal ordinance. It's alleged that you committed
Michael Howell?
Trespassing after warning in the city of Fort Lauderdale. Do you understand that, sir?
Yes, sir.
All right, you have two options. Option number one is I'll release you because the city prosecutor isn't here.
I couldn't hear anything you're saying.
Option number one is I will release you on your own recognizance. Option number two is you can resolve this case today if you want to do so.
How would I resolve it today, sir?
I'd order you to pay a fine and close it out.
Okay. But can I don't have any money on my property. If I was to get out, I could pay it after I got out.
That's fine.
Okay, I'll do that, sir. Yes, sir.
So you want to resolve it today?
Does that behoove me to resolve it today?
You're going to plead it out. You're not going to fight the case. You're just going to.
Yes, I'll resolve it today, sir. Yes.
Anybody threatening or forcing you, making you do this?
No, sir.
You understand you have right to legal representation by the attorney of your choosing, and if you couldn't afford one, I'd appoint one to represent you.
Understood.
You understand that you're waiving any burden the city of Fort Lauderdale has to prove that you trespassed at the Westin Hotel. Do you understand that?
Yes.
You understand if you're not a citizen of my beloved United States of America, the answer to this plea could result in your deportation.
Yes.
Anybody threatening or forcing you to do this?
No, sir.
How do you plead?
No contest.
No contest. Not under the influence of anything, are you?
I'm detoxing right now, sir.
Do you understand everything I've said?
Yes, sir.
Everything I've said.
Yes.
You certain of that?
He's confusing me now.
Now you're confusing him. He just wants to make sure that you understood everything he said about the state having to.
Yeah, yes, okay, yes, I agree. I'm sorry.
You agree?
Yeah, I'm sorry, sir. Yes, I
Withhold
understand.
$78. Have a good day. $38. I'm sorry.
Done. You go.
Michael Howe. Michael Howe.
North Broward.
North Broward.
Howe. H-O-W-E.
Your Honor, I don't have that either.
Mr. Howe is charged with 2 municipal ordinances for open containers. Mr. Howe, you want to resolve these cases?
Yes. I want to resolve them.
Anybody threatening or forcing you, making you do this today?
No.
You understand you have a right to legal representation by the attorney of your choosing. If you couldn't afford an attorney, I'd appoint one to represent you.
Yeah, I couldn't afford it today. I just want to.
If you want an attorney, I'll get one for you.
No.
You want to resolve it?
Yes.
Are you on probation or parole?
No. I've been in the hospital.
All right. Are you a U.S. citizen?
Yes.
How do you plead?
Guilty.
All right. Withhold court costs both cases. Good luck to you, sir. David Picard. David Picard.
County, Your Honor.
Mr. Picard, I have a no bond warrant out for your arrest. Good luck to you, sir. Zhivago Rogers. Zhivago Rogers.
Main jail.
Mr. Rogers, I have 3 counts of violation of community control and or probation. You're going to be remanded no bond on all 3 charges. Good luck to you, sir. Your next court date, just so you're aware, is July 28th. Good luck. James Cross. James Cross. Mr. Cross, I have a no bond warrant out for your arrest. Your next court date is July 20th. Have a good day. Dale Colwell. Dale Colwell.
Main jail, Judge.
Mr. Colwell, I do find probable cause. Your bond on count 1 is going to be $1,000. Your bond on count 2 is going to be an ROR. Have a good day.
Judge, we're going to move for reconsideration of the bond. Based on the nature of the charges and Mr. Caldwell's recent attempts to enroll himself into the BARC program, we're asking the court to intervene here in a therapeutic way, put him on pretrial release with a condition that he attend BARC and follow any recommended treatment. He has no family here. He has no bond to help. He does, however, have a place to stay when he gets out. He's been here for about a year. Judge, as I said, we're asking for the court to intervene on his behalf at this time.
My only contention is the probable cause of possession. There was no actual substance in his possession, although they did find the pipe itself and had burnt white residue. That's not rising to the level of probable cause.
And Your Honor, it also field tested positive for the presence of cocaine.
I understand your argument, but pursuant to the statute, it does qualify when the officer, and I choose my words with caution, chooses to charge the felony for the possession of the pipe. If it field tests positive for the substance, it meets the minimum threshold.
Minimum threshold for.
Possession of a controlled substance, in this case cocaine. All right, so you want to put him in bark?
Yes, sir.
Your Honor, he does have a lengthy history of adjudications for possession of cocaine. Going back. His last adjudication for possession of cocaine was in 2000.
2000.
Yes, Your Honor.
He's shaking his head yes, acknowledging that he has a problem.
And he was just released from Florida State Prison, October 26, 2015, on a burglary with assault and battery.
Just released 11 months ago. Anything since then?
Your Honor, I don't see anything since he hasn't had any adjudication since 2000. Apparently, he was in prison and.
He did 15 years Florida State Prison.
So the burglary, I guess, what's his age?
Counsel, don't worry about it. All right, in reviewing the probable cause affidavit, he was not compatible with law enforcement. He self-reported possession of the pipe. These are things I can take into consideration on establishing what we're going to do with him. He has no money.
Do you have any money?
No, sir.
I can advise the court that it is his intent to, was it Broward House? To get into Broward House. He does have a place to go now, and I explained to him that this.
1039 Northeast 3rd Avenue, sir.
And who lives there?
It was just me with my other friend, but he's not there. That's why I'm in here now, because of him. I took the rap for him and I shouldn't have. It wasn't
go
on
back
me.
and stay at the place where you took the rap for the guy with the drugs.
No, it wasn't there. This happened in Wilton Manor, sir. It didn't happen in this place. It happened in Wilton Manor last night. We went to see someone else last night. All I want to do is get treatment. I don't care about nothing else. I really don't.
I like that attitude. Defendant's bond's going to be set at the amount of $1,000. In the alternative, the court's going to order the defendant to the first available bed at BARC, which will obviate the monetary bond. If the when can we get him into drug court?
That's up to pretrial.
Huh? Say again? PD?
Oh, I believe that's up to pretrial. Pretrial can transfer the case to drug court.
And if he has a prior felony conviction, I do believe that does disqualify him from drug court.
Well, that's a decision I'll let the division judge make.
And that's going to be back on the PD and the division.
So, no. I'll let the drug court judge decide whether or not to bring him in, not the division judge. So when can we get him to drug court? Sorry to put you on the spot like this.
Your Honor, based on my knowledge, we won't be able to recommend him for drug court because he has that prior felony conviction.
I understand your position, but I have the ability to override your recommendation and order it to happen. So when's the next available drug court date? Do you know? Okay, that was my question. Thank you. Ma'am. As it stands right now, it's $1,000 bond. If he has the $1,000 bond, he'll be on his own to proceed with drug treatment. But if he can't post the $1,000 bond, which he says he can't, I want him in the first available bed at BARC.
Trial release or.
To BARC, or in the alternative, the $1,000 bond. Pretrial release to Bark if he can't post a $1,000 bond.
We will be supervising the state. Okay.
Yes.
So I'm gonna write an order for pretrial release.
Yes. My goal here is to get you into drug court immediately where somebody can sit down and talk to you and figure out what to do. That's my first goal. In the alternative, if you can come up with $1,000, I don't have a legal basis to leave you in custody. The third option is I put you in the first available bed, but I don't know when that bed's going to be. So whatever comes first is how we're going to help you. I'm not doing any of this to punish you. I'm doing it in an effort to get you the treatment that you need. Do you understand what I'm saying?
Yes, sir.
All right. I want you to follow up. Are you appointed on this?
Yes, Judge.
All right, so let's follow up on this today or tomorrow. I want him in, who's doing, I've been at North so long. Who's drug court judge now? Is it Tobin Singer? Let's get him to the first available date at Tobin Singer, and I'd like you to follow up as an order of me to do so.
Roger that, Judge. I would request at this time if the court could sign an order allowing him to participate in the SAP program.
Done.
While he's, thank you.
Absolutely. Do you want
All right.
anything else like life skills or anything like that?
Anything. I don't care. Anything. Right now I need to get my life together. I ain't got it together at all. And I just did 15.
I'd love to help you with that. I really would.
Your Honor, is it Broward House or is it Bark?
Bark. I want him SAP until we can get him in Bark or drug court can intervene.
Shall be in the SAF program until bed.
You know, normally my 200 magistrates take about half an hour. I'm sorry to make you sit through that.
That was a reputation I heard.
Address 1039. What was the address? 1039?
I guess we are going to make lunch.
Yeah.
That's the address that's on the booking sheet.
He was giving an address, 1039.
That's what's on the booking sheet. Is it $1,000? Are you thinking on pretrial?
No, we got
1,000 or in the alternative pretrial. But that pretrial supervision is going to be through Bark. In other words, I don't want him wandering the streets because he's going to hurt himself or somebody else. No, it's or.
If he posts a bond, he could get out.
Or if we can get him a bed and Bark, he gets out.
Then he'll be embarked. He'll be released to Bark with pretrial supervision.
Yes, ma'am. In lieu of monetary bond. All right, sir, we're going to do what we can do. I'm done with this now, but I wish you the best of luck, and hopefully you can get this under control.
All right.
Thank you, Judge.
Good luck. Fabian Frazier. Mr. Frazier, you have the 2 no bond warrants for violation of probation. Good luck to you. Tyrone Burrell Wilkie. Tyrone Burrell Wilkie.
Cleveland Thomas?
Yes, sir.
All right, you have a violation of probation. That's no bond. As to the trespass, I'll release you on your own recognizance. Good luck to you, sir.
Judge, what does that mean?
Cleveland Thomas. Mr. Thomas?
Judge, Mr. Thomas is present at the main jail. I would ask the court to resolve count 1 so that he can be on his way to deal with counts 2 and 3.
Do we have a DL on Mr. Thomas? Mr. Thomas, you want to do that?
Jeffrey Prescott? Remember we talked about you resolve this one, then you can go deal with that other county?
Oh, yeah.
You can either bond out or they'll come and get you.
Yeah.
Mr. Thomas, I have to be satisfied that you know what's going on. In order to do that, I have to ask you some personal questions which might hurt you. Do you understand that?
What might hurt me?
Yes. So listen to my question.
Yes,
All
sir.
right. You have 2 out-of-county holds on you. Do you understand that?
Yes, sir.
Do you know what they're for? You do not have to answer this question, but if you want me to resolve your Broward case, I need to know.
Do you know why the other county wants you?
What, Palm Beach?
Yes. Do you know why they won't?
Oh, yes.
You don't have to say why. You just say yes or no.
Yes. Yes.
Burglary, conveyance, and grand theft.
Stand up straight.
All right.
They have.
Well, no matter what it is, I mean, this is his first DWLS. So he's going to get a withholding court cost. So regardless of what it is, the concern becomes whether or not the entry of this plea is going to put him in additional peril.
Operating without a valid license is not a strike. For, are you talking about,
His out-of-county holds.
yeah,
I have no idea. At a minimum, it's 0.1 points on his criminal score sheet.
maybe it's community control or.
All right. Counsel, I'm aware of your request. Respectfully, I'm going to decline it. I'm going to release the defendant on his own recognizance on this charge.
Thank you, Judge.
All right. Good luck to you, young man. So we'll get you up to wherever you need to go. I think that's a better solution, Counsel.
Thank you. Okay, so you don't have to post a bond on the Broward case. You just have to post a bond on the Palm Beach County
Jeffrey
case. Do you understand
Prescott.
that?
Jeffrey Prescott.
But what?
I'm saying like, so I have to get transferred to Palm Beach County like that.
Mr. Prescott, good morning. The court finds probable cause.
Okay.
Counsel, you renewing your argument about the using the Q-tip to find a little bit of cocaine?
No, this is different. This is possession.
He did a pat down and it fell out of the guy's pocket.
Yes.
At which point he immediately recognized it as paraphernalia. At which point it field tested positive for cocaine. So again, one more time. Are we back to your argument from the other case?
Yes, it's the same argument raised in the other case that there is no actual possession of a substance that they find says that it's commonly smoked crack, and that there were burn marks. They scraped off a white residue, and that white residue makes it a paraphernalia, but does not make it a substance. And just as I know this doesn't go to probable cause, but the fact that how he obtained it was because he went into his pockets to obtain a knife that was already in plain sight. So there's some suppression arguments there, but that's for another day.
Got anything you want to hop in with? All right, count one, your bond set at $1,000. Count two, you're released on your own recognizance. Have a good day. Demiris Fields. Good morning, Mr. Fields.
President, the main jail judge, Matt Glassman, is Mr. Fields' attorney.
All right.
Brandon Wilson, is this yours, sir?
Yes, sir.
Can you pick it up? Thank you.
Sir, your bond on count one set at $10,000. On count two, you're going to have a no bond warrant. Good luck to you, sir.
I'll call Matt.
Brandon Wilson.
Main jail judge, we're seeking ROR for this
First
charge.
one's 10K, second one's 1K. Say again, counsel, I'm sorry.
We're going to be seeking ROR for this charge.
Basis?
Mr. Wilson has informed me that this is his first adult arrest. He's graduated Piper High. He's a lifetime resident. He supports a 1-year-old and, a 2-year-old son, and has one child on the way. He does not have money to bond him out. He'll be be asking his family to do that for him. He is currently unemployed. He previously worked at Char Hut, so he will be looking for employment once he's released.
State any priors?
No, Your Honor, not in Broward County as an adult.
Counsel, your client allegedly, at a minimum, was driving the getaway vehicle used in a burglary of a conveyance. I have some serious angst giving him an ROR, but based upon your stellar arguments, I'm gonna reduce his bond to $2,500 on count 1 and $500 on count 2.
Your Honor, we were gonna request.
Thank you, Judge.
Oh, she wants to take him. BSO wants to put him on pretrial.
And if the courts have any issues regarding public safety, that can be either standard supervision or electronic monitoring, given the nature of the charge.
Brandon, I'm gonna let you make this decision. You ready?
Yes.
All right. So option number 1, your bond's gonna be $3,000. Option number 2, you're gonna wear an ankle monitor for a little bit. Which one do you want? And no money. You get out.
Ankle monitor.
All right. So ordered. Let's put him on an ankle monitor.
Judge, pretrial, could you please let us know, can he be released this weekend or does he have to wait till tomorrow?
He'll get out tomorrow.
Okay.
I want to do pretrial.
Judge, he's rejecting pretrial.
Okay. Well, that causes me a little bit of angst. His bond set at $3,000. Have a good day.
Thank you.
William Johnston. William Johnston.
Main jail.
All right, sir, I
Michael
do find
Trist.
probable cause. Any arguments from anybody on this? Bond set at amount of $1,000. Have a good day, sir. Michael Trist.
Good afternoon, Your Honor.
Good morning, or good afternoon. Yeah, good morning. Sir, I have a bond warrant for you on a 2014 felony case, so you're going to be in court on July 19th at 9 in the morning. Good luck to you, sir.
Thank you, sir. You have a great day.
You too. Addison Bishop. Addison Bishop.
Main jail. Roosevelt River. Could you sit here for me, please?
Why? Granted.
You want Johnson back?
No. We're going to do a photo order on it.
Thank you.
Mr. Bishop, good morning to you, sir.
Good morning, sir.
So on 2016 cases, you have no bond warrants. You have 2 new substantive charges. Both of them, I'm going to set your bond in the amount of $1,000. Good luck to you, young man. Huh?
Down you go, please. Down the
Wait a
middle,
minute.
please.
We have arguments.
Wait. Come back.
So you need to go get one, is what you're telling me? So write it on a little note, and we'll get it afterwards. You're not gonna... All right.
So if we're moving on.
Figure out which one you want to do.
Sure. Charge 2.
Okay. Charge 2, possession of an anti-shoplifting control device or countermeasure. Go ahead. Okay.
Okay. Yeah, I could have him sit down. Or is he dealing with him now?
Yeah.
I see no probable cause that we had anti-shoplifting or inventory control device.
So you're saying the pliers doesn't work? You use pliers to cut off the thing. That's not a legal term, but...
Yes, sir.
It's on page 2 of the probable cause affidavit, and it reads, might be page 3. Towards the bottom. The suspect then proceeded to go to the domestic section, and this is when Baglio was able to see suspect taking all the merchandise production side wraps off the items by cutting them off with a pair of pliers.
An anti-shop?
Yeah, he used the plier. When I go buy something of value, you know, it has that little thingy that they put around it. Well, in order to take that off, one of the ways that people allegedly do it is take a pair of pliers and cut off that device, so that way when they walk out the door, it doesn't go ding, ding, ding.
No, you want to know which charges.
That qualifies.
Yeah, you know what the charge was.
Right, countermeasure, which is the pliers when he cut it off. You with me? You understand what I'm saying? I'm not asking you to agree with me.
I understand what you're saying. Yes.
Okay then. So, count one, $1,000. Count two, $1,000. Count three, you have a no bond warrant. Count four, you have a no bond warrant. Good luck, young man.
Judge, may I call one out of order, please?
Sure.
Kevin Muzan, he's on page 19 of your docket. Please come stand here and talk to the judge. Okay. If you have any questions about why you're here, this is the man to ask, okay?
Yeah, I don't see a package for that.
Hang on for 1 second. Let me see if I can find him.
He's a medical reset from yesterday.
Okay. I got it. Kevin Muzan. Mr. Muzan, you're here. You're charged with burglary of an occupied dwelling, unarmed, and 1 count of grand theft. Do you understand what I just said?
Yes, but I am being falsely accused, Your Honor.
Okay, hang on for 1 minute. Mr. Muzan, I want to caution you. Everything that you're saying is being recorded right now. Do you understand that?
Yes.
So as you proceed to try and explain stuff to me, you can't see them, but I got a couple of state attorneys, and I've seen pens in their hands all morning. And they're going to write down stuff that you say to me, and you're not going to be able to say you didn't realize that it was being recorded. Do you understand that?
I understand.
All right, you also need to understand something, that before you start talking to me, I'm going to put you under oath. Do you understand that?
Yes.
Are you represented by an attorney right now?
I have an attorney. His name is Adam Harmon.
Very good attorney. Very good attorney. Who is not here right now.
No, because I've just...
Yeah, good job. Hold that button for a minute. So having said that, you understand when you start speaking to me based upon, heck, I started in law enforcement at the age of 18 and a half in the military. Generally, nothing good is going to come from this conversation. It's not going to assist you. Sometimes it does, but the odds, as they say in Hunger Games, are not in your favor. So, sir, I would suggest you don't say anything in the strongest possible way. Now, having said that, you can undo it. You want to tell me something, sir? Yeah, you want to tell me?
I actually, I just would like to remind the court, and perhaps to tell him that he has the right to ask the court to contact his attorney and have his attorney present for this hearing. He does not have to go forward today if he has counsel.
I would agree with you, but the question becomes, is this an attorney he's retained for this case or an attorney on retainer?
Well, right now, all we have is his information that he has this attorney. I don't know.
Sir,
I want to know why...
I ask him this. I don't want to hear what he says. Is this attorney representing you in this case, or you just have desire to retain this attorney? About 10 minutes, we should be done. Yes.
Okay, Judge, I think I've sussed this out. He intends to hire counsel. He wants counsel present. He's asked the court if we could provide a phone number for counsel so that he can reach out to him and then reset this case so that he has an opportunity to hire counsel to be present for this hearing.
So you're asking me to reset this as a friend of the court. You're asking me to get Adam's phone number. All right, can you have your esteemed co-counsel do that for you in a couple minutes?
If he has access to a computer, I'm sure it's on the Florida Bar website, and we'll get that number to him and ask the court to reset this.
We'll reset it until tomorrow.
And I would ask the court to wrap up this hearing ASAP.
All right, the court's going to defer ruling on bond. However, in the interim, as to count one, I'm going to set the defendant's bond at $10,000. As to count two, the bond's going to be at $5,000. That's pending a determination by the magistrate tomorrow after Mr. Harmeling's been contacted to discuss this. Sir, you're excused. Yeah, so go ahead and remove the defendant from the area at this time, please. Roosevelt Rivers. I do find probable cause at this time, however, it'll be reviewed again tomorrow out of respect for counsel. All right, Roosevelt Rivers, Mr. Rivers, on count, I do find probable cause. On count one, your bond set at $750. On count two, you have a no bond warrant out for your arrest. Good luck to you, sir.
Thank you, Judge. Before we get too far down the road, as a friend of the court, based on my observations here a few minutes ago, if you might want to consider ordering a mental health eval for Mr. Mouzon.
I appreciate that, and if I'm not even sure counsel is going to represent him at this point, so I am going to do that. Let's order a mental health evaluation on him. Counsel, if he wants to undo that tomorrow, to make that request, but I'm not terribly certain he even represents him. And if I don't order it now, he'll slip through the cracks, so let's do that. All right?
Yes, sir.
David Eisenbray.
He's present at the main. William Singleton, could you come here for me, Mr.
State, at this time I reviewed the documentation. I don't think it's disputed that potentially there was a crime that occurred here. But I have some serious angst with the crime that is charged here. What do you want to do?
Your Honor, there may be probable cause for at least for battery or an assault. But I understand Your Honor's position as to the aggravated assault with intent to commit a
Can
felony.
I find probable cause to a charge that isn't listed?
If it's a lesser included, Judge, I believe the court has that authority.
I tend to agree with you. All right, I'm going to find probable cause for misdemeanor assault. I'm going to set the defendant's bond at $500 at this time.
And then, Your Honor, I would just like to object to the record that, again, even assault, the person was not fearful and was the one that was engaged.
Outstanding argument, counsel. Bond set at $500. I'm also, sir, come back here. You're to have no contact with the alleged victim in this case. Do you understand that?
But I live in a... Get on the bus, I see that individual.
So what he's explaining, Judge, is they live in the same community, about a half a mile apart. There's a bus that serves that community, two buses that serve that community.
Well, yeah, they run every 45 minutes.
And so if he were on the bus and the alleged victim were to get on the bus, if the court orders no contact, then he would be required to get off the bus and wait 45 minutes for the next one.
Is that, yeah. All right.
Is that an accurate summary, sir?
Yes, sir.
You're to have no contact with the alleged victim in this case. If he gets on the bus, you get off the bus. Do you understand me?
All right, and if I'm at Publix and he shows up there, I have to leave Publix?
Go to Winn-Dixie.
Yeah. All right.
All right? Good
All
luck.
right. Thank you, Judge.
William Singleton. William Singleton.
Main jail.
Mr. Singleton, on count 1, you have a no bond warrant. On count 2, I'm going to release you on your own recognizance, okay?
Yes, sir.
Good luck to you, young man.
Good luck.
Denzel Williams. Denzel
Good morning,
Williams.
sir.
Nicholas?
Are you Denzel
Morning.
Williams?
Yes.
Denzel, next, are your parents still alive?
My parents?
Yes.
Yes.
All right, next time you talk to them, I want you to tell them that I'm jealous. Because they picked a much better first name than my parents did. All right, John is very bland. Denzel has a certain machismo to it. You know what I mean?
Okay.
All right, on count 1, I'm going to release you on your own recognizance. Having said that, you're in violation of some kind of felony supervision requirement. You're going to be held no bond on that, but you're going to be in court on July 20th. Do you understand that?
Okay, thank you.
Good luck.
Yes,
to you,
sir.
man.
All right, thank you.
Thank you, Judge.
Nicholas Lowe. Nicholas Lowe.
Yeah.
Mr. Lowe, good morning to you, sir.
Good morning, Your Honor.
Any arguments on this? This is the gun
Excuse me?
pointing it at several people in the car. Any arguments? Go ahead. Further, for the victims stated they were in fear. Now, I would agree with you. I'm not sure that's where the apostrophe is supposed to go, but it is a plural to it.
Where's that?
4 lines from the bottom. Furthermore, the victims stated they were in immediate danger, in fear, and believed they were going to be shot. There's an S which indicates plural. Court finds probable causes. Count 1, your bond set an amount of $10,000. It's count 2.
As far as pointing at them after our arrival, you can't point a gun at multiple people unless you're brandishing it, and it's not being allegedly brandishing it. There's only one.
I would submit to you, counsel, and I want to be abundantly clear. If I reach down and take this Glock off my ankle and point it towards you, those two are going to be petrified. So with all due respect to you, the court does find probable cause on all 3 counts. Bond set an amount of $10,000 on each one. So your cumulative total bond is $30,000. You're to have no contact in any way, shape, or form with the Harrigan family. Do you understand that, sir?
Yes, sir. Yes,
Good
Your
luck
Honor.
to you, young man.
Judge, at
Thank
this
you.
time, we would move the court for reconsideration of the bond amount based on his significant ties to the community.
What are they?
He's originally from Boynton. Moved there in 2011. He moved to Fort Lauderdale, and about 6 months ago, his family here in Broward County includes his mother, his aunt, and his uncles and cousins, also a girlfriend. He's a supervisor at Target. He's been working there since 2013. He has money in the bank, however, he does not have access to that money today. He doesn't have a debit card to get money. He's going to be asking his girlfriend to bond amount. Judge, I would ask the court to set the bond at $10,000 total.
State prior criminal history.
For Mr. Lowe, Your Honor, I don't see any prior criminal history in Broward County.
Gonna add, is he your client?
Yes, Judge.
I'm going to ask him a question before he answers it. I want you to look at your attorney and see whether or not you want to answer this question. You may want to tell him the answer beforehand, too. Raise your right hand. You swear and or affirm to tell the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, mute that thing for a minute. According to my records, you have no criminal history. You're under oath. If you lie to me, it potentially could get very messy. Do you understand that?
Yes, Your Honor.
All right, so my question to you is this. Have you been charged with a crime before in your life?
Your Honor, are you asking conviction or are you asking charge?
Charged.
And that's.
And also, he said he's from Palm Beach. He's from.
And I think that I'm allowed to take that into consideration.
Judge, I have no objection to Mr. Lowe answering that
I'm
question.
thinking the answer's going to be no anyway. All right, sir, have you been charged before?
No, Your Honor.
Nothing.
No, Your Honor.
You got nothing, right?
And Your Honor, it actually says he's from Jamaica, so as far as Broward County, I don't have any priors, but.
All right, count one, the court amends the bond to $3,000. Count two, the court amends the bond to $3,000. Count three, the court amends the bond to $4,000. Anything further on this case?
No, thank you, Judge. Thank you.
Young man, you better stay away from
Thank you,
that.
Judge.
You hear me?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge.
Coleman Davis.
Thank you, Your Honor.
North Broward.
Mr. Davis. Coleman Davis.
Yes.
North Broward.
Mr. Davis, good morning to you, sir. All right, you have 4 active no bond warrants at this time on case number 1323162MM20A, case number 1535553CF10A, case, it might be 16. And that will be all 3 of those additional counts. You're remanded no bond, Sheriff of Broward County. You're going to have your violation of probation on July 21st and misdemeanor and your felony case on August 1st. You'll be in custody until that time. Good luck to you.
Judge, may I call one out of order, please?
Bearing in mind I only have like 8 left, but sure.
This is actually the last one on your docket. It's a reset from yesterday for perfection. Mr. Davis.
All right, counsel, you asking me to also reconsider count 1, which I already set a monetary bond on.
Yes.
All right, let's start with count 2. State, do we have any indicia or have you received any additional information as to the dollar amount?
Your Honor, looking at my email that I have up here, I have not received any additional information.
All right, so at this time, I'm going to consider it a misdemeanor theft because the PC indicates that property was taken. I'm going to set the bond on that misdemeanor theft at $1,000. So now, huh? That's count 2. Now let's go back to count 1.
Yes, Your Honor. Under the case
I
law-
set his bond at $25,000 yesterday, didn't I?
You did. I can correct the court.
I read the case.
Okay. Specifically, it's citing Mitchell v. State, 698, Southern SO.2D55 on page 559, Florida 2nd District 2DCA, and the case on point that's citing that case is Brown v. State, out of 2005, 5th DCA 896 SO.2D808. The crux of the argument is that this could not have been a dangerous weapon because under the case law, a dangerous weapon, although not defined in the statute, has to take into account the manner in which it is used in this particular instance.
Which was to break open the medicine cabinet, assuming the information's correct, which is an assumption, don't misunderstand me.
Right, and then taking into account the way it is used means the way the object is used in a particular case. And in this particular case, it's not used as a dangerous weapon, as in harm on somebody. And so it finds that case, and so the case cited. To go specifically into it, a standard jury instruction for a deadly weapon, which the court found to be anomalous to a dangerous weapon, if it is used or threatened to be used in a way likely to produce death or great bodily harm. That's the jury instruction of the anomalous, or of the comparable definition. And so because it's defined in part by the manner in which the object is used, and that this specific thing did not constitute a dangerous weapon because it was not used in a manner likely to produce death or great bodily harm, citing Mitchell.
Outstanding argument. Do you have anything you want to add? No, that's it? All right, your
you some
argument
background on
resonates
it.
with the court, counsel. I'm going to agree with your argument, at least for purposes of today's hearing, but I am going to find probable cause to a burglary of an unoccupied structure. Defendant's bond is set in that matter in the amount of $25,000.
Judge.
Counsel, if the probable cause information is accurate and correct, which I need to consider at this time, your client allegedly, and I want to be abundantly clear, allegedly broke into a major store in the middle of the night and brazenly stole countless items to which I can't even quantify, then hopped in a vehicle which fled from law enforcement, and when the vehicle became disabled, then proceeded to flee. I understand your advocacy, and it makes perfect sense. But in the list of factors that causes me grave concern, this is pretty high up there. Not only did he place the residents of Broward County in jeopardy, he placed himself in jeopardy. He should probably be glad, and I am glad, don't misunderstand me, that you are alive and do not have various puncture wounds in your body as a result of your apprehension. This crime causes me substantial concern because you can't get much more brazen than this.
There's actually a person in the building and that.
Oh, absolutely, and then there would be no bond. And I've given him a reasonable monetary bond in the court's opinion. I've explained for purposes of appellate review, because I don't hide anything from anybody, what my basis is. And on the scale of seriousness, this is really high up there, in my opinion, and I am the elected judge in this case. I'm not doing it to pick on you or give you a hard time, but you can tell me whatever you want to countermine my 50 years of life experience that tells me this is serious. Go ahead.
No, that's not what I'm going to. Yes, we understand the light of the seriousness of it. However, this is not a capital. And this is something that has to take into account his ability to pay, because even if being high is tantamount to not being paid at all.
I would agree with you.
And because of that, we believe the court is not looking at his ability to pay and setting it and reducing it. Although both charges now, two different charges, have not sustained the probable cause of that.
Understand that. His bond is at $26,000. And based upon my understanding and experience, that translates to somebody raising about $3,000 to get him out. Now, if you want to make an argument to me that he can't pay that bond, then I'll go to the next step in establishing a secure method to track him, which I'm not terribly certain he's going to want to participate in. You want to have that conversation with your client?
Well, the question I just asked him is if he's interested in going out on an ankle monitor, and he was quick to agree to that.
He was quick to agree to that. State, any concerns about me putting him on a GPS monitor?
Yes, Your Honor, and just based on the facts that Your Honor was just reciting, I would be objecting to that and ask that you keep the $26 bond.
And again, State, the judge giveth, the judge taketh away as we're having these discussions. You're telling me that society is better protected by him posting $3,000 than us knowing where he is 24 hours, 7 days a week. Because that's the argument, and I'm not criticizing your position. But my job is to protect society. And the best method, if I could, short of capital felonies, and it was appropriate in every case, I want to be abundantly clear so I'm not stricken from cases, I think a monitor is a very restrictive mechanism to supervise people. And I would never be adverse to an agreement to a monitor. I'd bankrupt the sheriff's office in the process of doing it, so it's not viable, and it's not appropriate in most cases. But if this young man is telling me he wants to go on a monitor, I think that society and my obligations to give him a reasonable mechanism to release while protecting society's interests is covered. So your objection is noted and overruled.
Yes, Your Honor.
Judge, I just want to throw a little bit more into the mix. He is a lifetime resident of South Florida, graduate of Miramar High School. All of his family lives here in South Florida. He is currently unemployed. He is actually collecting unemployment as he's looking for another job.
We'll waive the cost
and
of
he's
supervision.
Sorry?
We'll waive the cost of supervision. We'll get there in a second.
He is supporting a 1-year-old child. He does not have any money in the bank. He is a registered voter.
Okay. Prior criminal history, State.
Your Honor, I don't have a BCCN to pull up because I don't have a packet in this case since it was a reset.
I was just going to inquire, is this now, the probable cause wasn't found on the hire, does this require the state to amend the information? Or I guess I don't know the information yet.
I don't know the answer to that.
How does that?
I don't think it does. I can find probable cause and go ahead and place him on what I think is appropriate for what I find probable cause, and these would be lesser included.
But if probable
Correct, Your
cause
Honor.
is not even found,
They can file whatever it wants to file. And
Correct,
then you
Your
have an argument down the road as to the legitimacy of the information. I don't have any authority, nor do I desire to have any authority to tell the state how to do their job or to tell you how to do yours. I'm like the soccer referee. Most of the time I go play on, but sometimes I've got to stop it. This is not one of these situations where I need to get involved. All right. So explain to me again, it's been a little bit, the difference between level 1 and level 2.
The residence is for a court and to see his attorney.
That's what I'm picking.
And Your Honor, for the record, I don't see.
Unemployed, counsel.
Judge,
Go ahead.
he is collecting unemployment, which means he's actively seeking employment, and we would like for him to have that opportunity to get a job so that he can support his child.
The court will approve and order level 1 GPS. The defendant may leave his residence for the following reasons: necessary medical treatment as documented, food as necessary and approved by his supervisor, any and all legal meetings, and any employment meetings which he can verify. In other words, as he's looking for employment. Do you understand that, young man?
Yes.
Good luck to you. Anything further on this?
Judges, to clarify, count 1 is 25,000.
No. We're going to put him on level 1 GPS pretrial. On all counts. Does that
Thank you,
work?
Judge.
Does that work for you?
Works for him.
Pre-trial with GPS monitoring. Medical necessary. Food allowed.
They can get with the state on that. Okay. Let them know.
I guess when you're done.
Pretrial, write the order. All right, so
May he be
let's move on.
excused, Judge? And I apologize to the court. One more at your convenience. It's also a second one from
Is
yesterday.
this getting you out of here if we do these?
Yes, sir.
All right, go ahead. What is it?
Thank you, Judge. It's Mr. and it starts with a W.
Sir, if you can give me the ankle bracelet, I'll do anything for you to do that.
Daniel Watlusky.
Yes. Yes, indeed.
I'll do anything, sir.
Here he is. Last page. And he is requesting an ankle monitor as well.
Cousin that I can work with.
Prior criminal history on Mr. Widoslawski.
Your Honor, I'm looking him up in the docket right now. Unfortunately, I don't have a packet for that as well.
Okay. We'll be off the record for 30 seconds.
Yeah, can you call him, please?
All right, that had nothing to do with you. It had to do with the earlier cases, so don't misunderstand. Counsel, how you doing?
but there is confusion on the last case on, they can't change the charge on pretrial release.
Leave it the way it is. Leave it the way it is. We have to make a form over substance decision. Either we could leave it to, we could make a substantial issue out of substance, you know what I mean, a substance-oriented issue out of it, at which point we're gonna waste additional hours trying to sort that out. It's not a document that controls the charges or the information.
What concerns me though is that in the proliferation of everything, arrest records are now readily available and.
Absolutely. We'll reset that for tomorrow.
Okay.
We're gonna reset that whole issue for tomorrow, state and BSO to coordinate, the defendants to remain in custody until tomorrow. You may wanna get with your cohort to make sure he's, the gentleman that we were gonna put on pretrial.
Get with my cohort and do what?
Let him know that you're opting to, and I'm not being critical when I say that, leave this kid in custody for one additional day.
Well.
Because I think the kid has a right to be involved in that.
I wanna ask him.
For Davis?
Yes, for
He's
David.
still not, with the monitor,
Yeah.
he's gonna be in custody until we verify an address where he'll be residing anyway, so he's not automatically going to be released, Your Honor.
I understand that, but I can't, based upon your objection, and again, I'm not giving you a hard time, don't misunderstand me, but I can't sign an order that you're objecting to because under your thought process on public information and that sort of stuff, I can't sign an order at this point. It's gonna have to be rolled until tomorrow, which means if they could sort out 2 hours from now where he's going to, he's not going to get out until tomorrow. And I think that's a decision that he has to make, not you. Do you understand what I'm saying?
I do, but I'm just trying to figure out exactly what the order.
Right now, it's nothing. We'll roll it till tomorrow. We'll let Judge, the judge hearing it know what my decision was, your objection. I sustained your objection for BSO to generate the right paperwork. I could offer you my opinion, but I won't. But I'll comply with your request, but your client needs to make it, not you. Now, you need to talk to him about it.
I guess.
What do you want to do? Okay, again, I want to be abundantly clear. I'm not telling you I won't do what you want. Just, we'll be off the record for a minute. Any objection?
Can I consult with my co-counsel, Judge?
Yes.
Thanks.
We'll be off the record so you can do that. I don't even know how to turn this thing off anymore.
Hey, so no, they
Can
were
you say-
trying to put
We'll be back on the record. Counsel, at this time, are you withdrawing your objection?
yes, withdrawn the objection that the paperwork be changed.
Okay. Counsel, or ma'am?
So I just need to know what we're doing, Judge.
We're putting him back on level 1 GPS. As we had decided beforehand, we're leaving the information on the paperwork the way it was.
Okay, so we're not RORing and we're keeping all the bonds in place.
We're putting him on pre-trial. No monetary bond. All right, Daniel, I'll call you Daniel. Good morning, Daniel.
She said okay. She said.
Did we already get a photo order for Mr. Widoslawski?
If we didn't, we'll do another one for you.
Please, thank you.
You got that written down? You need some orders? Austin, you need some blank orders? Do you have some in your stash? Oh, okay.
What's the order that I need?
Widolowski, a photo order. All right, anything we want to discuss as far as this goes?
Yes, it's a perfection issue, Your Honor. Is it protected?
What was the argument on the perfection again?
Well, I don't have that in front of me. Got the, I guess the amount.
What?
Burglary, conveyance, unoccupied, unarmed.
No, armed is, it was charged as armed. Oh, okay, so the third one is that it's armed. I don't know why it's armed.
Allegedly, Judge, he was found with 2 pocket knives and 2 Leatherman tools. And I think the argument that counsel made previously applies in this case. There's no allegation that the knives were anything other than common pocket knives. In fact, it says it's 2 pocket knives. And unless they're used in a manner that makes them a weapon, they are just common pocket knives and not considered to be a weapon. And so the armed burglary would not stand in this case.
All right, State, so the defense is arguing that he wasn't seen in possession of these weapons and he was apprehended 4 hours and 46 minutes later by my map. So, in looking at the probable cause affidavit, it's alleged that at 3:08 in the morning this occurred. The date time arrested by the police officer is 7:54 in the morning on the same day. So you have a 4 hour and 46 minute, give or take a minute either way, period in between the crime and the apprehension. There's nothing in the probable cause affidavit that indicates that he was in possession of these items at the time. Do you understand the argument?
Understood, Your Honor.
Do you have a response at this? Bear in mind this was reset from yesterday.
Yes, Your Honor, and at this time I'm going to defer to the court.
All right, the court does not find probable cause as to count 3, the armed charge. State, do we have any indicia on why there's 3 counts of burglary?
I don't, Your Honor.
As to count 2, the court amends and finds no probable cause based upon the information. As to count 1, the court does find probable cause as to the burglary. What's the prior criminal history on this young man?
Your Honor, for Mr. Witzlowski, I don't see any prior criminal history in Broward County.
Do we have any indicia of the value of the property that he stole?
Not at this time, Your Honor, besides what was in the probable cause affidavit.
As to count 4, the court finds probable cause for a 2nd-degree misdemeanor theft.
So you're not finding on the record probable cause for the grand theft?
There's no way I can do that. All right. As to count 4, I said the defendant's bonded $100.
And, Your Honor, as it was 3, it was set at what? Oh, it was no probable cause. So.
Correct.
Okay, and then to count 1 and 2?
Give me 1 minute.
Sure.
As to count 5, what's the probable cause? He was in a bush?
Your Honor, unfortunately, I don't actually have the packet in front of me, so I will defer
Well,
to Your
I
Honor.
do.
Yes.
Says, defendant fled on foot and was found inside a fenced-in yard by K-9 Romero while resisting without violence in a shed. How was he resisting without violence? Got
Yeah.
nothing for me.
Your Honor, unfortunately, all I have are what Your Honor read out on the record, so I'll defer to the court since you have the probable cause affidavit in front
The
of you.
court doesn't find probable cause as to count 5 in light of the fact that there was a 3-hour delay and the report doesn't tell me what he did. And the fact that the K-9 got him to indicia, but it's not enough to get to PC. What?
What page are we on, Ron?
I didn't find PC on count 5.
Okay, so what page? My notes?
As to why I didn't find PC?
What page are we on? I just lost track a little bit.
We're on Daniel Widoslawski.
Page 21?
Oh, what page on the docket?
I'm sorry.
Okay. So as it stands right now, no PC on 3, no PC on 5, PC for a second-degree misdemeanor on 4.
And as to 1 and 2, is there a reason why there's 2 counts?
I'm doing pretty good at this on my own. It's working out pretty well for you so far. Hang on for 1 minute.
Go real fast.
Okay.
Hello? Curve on page 20.
State, I see a singular vehicle
No, it's not.
listed. I also see without permission to enter his vehicle, which again is a singular.
And Your Honor, so if there's 2 counts of burglary, I know Your Honor did mention that they found him within a fenced-in yard. And it could be presumed that if that's the curtilage, he is
That
committing...
is an excellent presumption, and he's even in a shed.
Correct, Your Honor. And if he's fleeing law enforcement, there's an argument to be made that he's committing a crime therein.
There is, and I think that that's a great thing for the filing attorney to look at when they're contemplating what charges to file. But I'm not in the business of making presumptions. No disrespect to your argument, it's well founded. Count 2, the court doesn't find probable cause in that, as it stands right now, I'm having to reach and grasp for reasons, and I gave you 24 hours to perfect this from yesterday. I'm not denigrating you when I say that, just you got nothing for me.
Yes, Your Honor.
In count 1, I do find probable cause is bond on that set in the amount of $5,000.
Judge,
Sir.
at this point, we'd ask the court to reconsider the bond amount, consider pretrial release for him. And again, we're looking for a BART component. Mr. Widoslawski came to South Florida in order to go to rehab. He lives with his cousin now, but it's his intent to go to a halfway house and to work on recovering from an addiction issue that he has to deal with. If the court would put him on pretrial, he has an address to go to. He does have family in the area, and he would follow any recommendations that BART would recommend for him.
Ankle bracelet.
Counsel, here's my concern.
And he'll take an ankle bracelet if you want to give him one.
There you go. Do you have a job, sir?
Yes, I do, sir. I do heating and air conditioning. I'm a technician. We're out of Boca.
His cousin's business.
His bail bond is only like $500, $600. So it's just, it'd be good for him to see if to take into consideration that as it stands, he can come up with $600 and be able to get out of the bail bond.
Do you two want to consult with each other? Because these 2 public defenders are asking for 2 different things here.
I've heard what I'm going to talk to my client now real quick.
Okay.
He'll take the ankle bracelet, Judge.
He wants the ankle bracelet.
Yes, sir. Apparently he likes the fashion jewelry.
Court finds probable cause as to count 1. The court places the defendant. Is level 2 the one where he just has to be in for curfew and stuff like that?
No, Judge, he has to give them a schedule. He has to keep the schedule. Failure to keep the schedule will violate his pretrial release and bring him right back here without a bond.
The address I'm looking at says he lives in White Plains, New York.
You got a local address?
He's going to provide a pretrial with a phone number of his cousin, and they can contact the cousin, and the cousin will be able to provide a local address.
I have the halfway house address that I stay at. It's 1412 Southwest First Terrace.
Why? Okay.
That's the halfway house down there.
Okay, so that's where you're going to be staying.
Yeah. 1412 Southwest First Terrace. Deerfield Park. The rent's only good until August.
Is that where you're hoping to go?
Yeah, 1412
So you're
Southwest
hoping to
First.
get into a halfway house. Your bond's
No, Judge, he's saying
$5,000. If in fact,
Judge.
if it,
It's
listen
paid-
to me, listen to me.
Yes, sir.
Your bond's set in the amount of $5,000. The court's going to order level 2 monitoring. All right. If you can get into BSO satisfaction to level 2 monitoring, but I'm going to give you a financial out as well. So I'm giving you the ability to do one of the two. Sounds to me like BSO justifiably is not happy in that they can't verify where you're going, what you're doing, things of that nature. If they can, they're going to let you out on pretrial. If they can't, well, then your bond's set at $5,000. So that way you don't fall through the cracks. Do you understand?
Yes.
Okay, thank you very much. Have a good day.
And would you please provide pretrial with the phone number of your cousin so that they can call him?
Cousin's phone number.
It's
Just say it.
He's gonna have to be interviewed by someone in the office.
561.
Stand by. Do you want to keep him in the courtroom?
Yeah, go knock on the door next door and have them come and interview him, because he has
Yes,
not been
ma'am.
interviewed.
Yes, ma'am. Judge, that clears us at the main.
Have a good weekend.
Thank you. It's a pleasure to work with you this weekend.
As
Judge.
always, Counselor.
We have count 1, 5,000.
Count 1's going to be $5,000 bond. The one misdemeanor petty theft is going to be a $100 bond. That was count 4, if memory serves me. And there's no info on 2, 3, and 5. All right, Keith Knowles. Keith Knowles.
Copy, Your Honor.
All right, Mr. Knowles, you're charged with 1 count of robbery, no firearm or weapon. It's an ad charge. Your bond set in the amount of $10,000. Have a good day, young man. Jamal Dukes. Jamal Dukes. Mr. Dukes.
Copy, Your Honor.
Good morning. And count
Good morning,
27, you're charged with burglary, unoccupied conveyance. 28, same thing. 29, same thing. Count 30, same thing. Count 31 and count 32, the same thing. Count 33, you're charged with 1 count of grand theft automobile. In counts 27 through 33, the court finds probable cause. Your bond set at $5,000 on each one of those counts.
Excuse me, sir.
Be very careful what you say, young man.
I just came to magistrate Friday for these same charges, and they were set at $1,000, and now they're being set at $5,000.
Apparently counts 1 through 26. These are new charges on top.
No, Your Honor, I have, I'm sorry.
Go ahead.
No,
I do have a finding.
I've been charged with these.
Sir, hang out for 1 minute. I promise I'll let you speak. Ma'am?
There is a finding in his file from 7/15/2016, signed by Judge Davis.
Mm-hmm.
I have it here that has counts 27 through 33, $1,000. So I don't know why he's before you here today.
Okay. So you're telling me that it reflects that his bond is $1,000 on each one of these charges?
Yes.
Okay, so it's going to be $1,000 on each one. You're correct, sir. Luckily, you were in front of Judge Davis before you got to me. Have a good day.
All right, thank you.
Your Honor.
No, they've already found probable cause. He shouldn't even be here.
Your Honor.
It was decided 3 days ago. Yeah, so this is a moot issue. I'm not trying to keep you from your PC, but another judge already found probable cause.
Your Honor.
Yes.
Mr. Knowles, that was heard right before
Good
Mr.
to see you
Dukes.
again. How are you, Deputy?
Hey, how you doing, Judge?
All right.
Yeah, I mean,
He was found
He had I was here Friday, Judge, and they on charge number 10 they gave me 7,500.
Count number 10? All right, let me see his too. What'd I give him?
You gave me 10,000.
On count 10? So what do we got on the rest of them? 11, how many ad charges does he have? Just 10 or more?
Just 10.
So it's just 10, so let's put that back to $7,500, young man. Good luck to you.
Thank you.
Have a good day, Your Honor.
Take care. Gene Alcindor. I'm going by what I have. Gene Alcindor.
Sir.
Mr. Alcindor, good afternoon to you at this point.
Good afternoon, Judge. I was here yesterday.
Yeah, I remember you here yesterday.
I'm sorry, this is for this case right now?
All right, Mr. Alcindor. This is the one where they're
Yes.
going to do an Arthur hearing in the division.
Yes.
Is that the PD on the case? Yeah, we got you, don't worry. All right, Mr. Alcindor, good morning to you. You're represented by a member of the Broward County Public Defender's Office. You understand that? Very good attorneys. And she's fighting really hard for you. And she and the Assistant State Attorney have reached an agreement that what I'm going to discuss right now is moot. What we're going to do is you're going to be in front of the division judge in the next couple of days to argue her motion to reduce your bond. Do you understand that? Don't say anything, but give me a thumbs up if you understood what I just said. Outstanding. So I guess we're back to the original question, which is, was probable cause found on these charges?
I don't have it in front of me.
Maybe she's still listening.
She's not present there right now, I guess.
No, well, somebody just called you, right?
Somebody did, yeah. You just said that she's not present right now.
So, Madam Clerk, do we know if we found probable cause on these charges? Hang on 1 second, sir.
I see that it was checked off, so, but it wasn't on.
I found probable cause. All right, the allegations on each one of these charges are egregious. It doesn't appear that we've actually gone to a bond hearing on this. He doesn't have his attorney here present with him now. They're having a bond hearing at some point in the next couple of days. So based upon that information, they're already setting an Arthur hearing as it pertains to this. In abundance of caution, can you check and see if he has bonds on counts 2 and 3? That could give us part of our answer.
What was the bond on Knowles and?
Alcindor?
Yes.
Alcindor got a bond. On 2 and 3, it showed 10,000 per count.
I'm sorry. I'm really confused where we're at with that. Okay, so for Knowles, what was the bond on Knowles? Oops.
So there's nothing in the computer what we did on those charges?
Counts what, 2 and 3, 2?
Yes.
2 and 3 for Alcindor, yeah, that shows that he has a bond of $10,000 per count.
On counts 2 and 3.
Yeah.
And what are counts 2 and 3?
Somewhere in the middle, molestation victim, 12 to 16 years of age.
Control radio check, radio.
Will those be lesser included, John?
Depending upon the amount of alleged activity, each one counts as its own, no. But again, I don't know the answer to the question. I don't have the information that I need from a paperwork standpoint. But I can find on numerous occasions since she was 12. That's what it says in the PC. So numerous is more than 2. You're also dealing with 2 separate alleged victims. All right. On count 1, I'm going to set your bond in the amount of $50,000. And count 4, I'm going to set your bond in the amount of $50,000. I make that decision. No, hang on, sir. I make that decision knowing and understanding that you're going to be in front of a division judge in very short order for a more detailed review of the case.
Yep.
What are 9
Your Honor, may I?
Sir, I highly suggest you don't.
No, I just wanted to just tell you that I had my bonds was done 10,000 on each count and 30.
I understand.
You just raised it up. You just raised it up, Your Honor.
I did, yes.
Yeah.
That's illegal. It's not allowed.
Counsel, these are new counts.
These are new counts?
These are new counts.
He said new charges. Okay.
He's talking about 2 and 3. And now he has 1 and 4.
1 and 4, the judge just lowered the bonds because the bonds was
Yes. Yes.
Right.
Bonds. The other ones, okay.
Yes, you with me on that? So yeah, no, not illegal. All right. So now, having said that, what am I setting bonds for on 9 and 10?
Habeas.
Habeas, sir.
Oh, but it's from the same case.
They're add charges. Yeah, add charges of sex assault, but add charges in the case.
What are they?
It's the same sexual battery, familiar.
So 1 and 4 are also 9 and 10. They were just the warrants prior to them actually presenting me for a bond amount. It's very tough for the court to make intelligent decisions when it's not provided information which affects
1 and 4 is change of charges. Right, 1 and 4 change of add charges.
9 and 10. So 1 and 4 are change of charges, and 9 and 10 are add charges, which are what?
Sexual assault by custodians or sexual battery victim over 12 under 16 on both counts.
Your Honor, we have no occasion to know if these are like lesser included or if there are other occasions.
Nor an explanation on what the basis of it is. So on counts 9 and 10, in an abundance of caution, the court's going to ROR the defendant. All right, sir. Good luck to you. Kirby,
She would get the bail down.
your attorney, who's a very good one, is going to work on that in the next couple of days, sir. And you'll be in
Thank you,
front of the
Judge.
division judge. I wish you the best of luck. Kirby
Thank you.
Telsine, Kirby Telsine.
There's no one in the main jail, Your Honor.
Thank you.
I'm not sure what. Welcome.
Do we know where Kirby Telsine is or Alton Kerr is?
This is a reset inspection because of that I made.
That's North Broward, Your Honor.
North Broward, got it. Your name, young man?
Alton Kerr.
All right.
That's not the same.
Perhaps a deadly weapon? I don't have it in front of me.
Section on the left.
I have no deadly weapon charges. I have burglary on occupied conveyance. I think this might have been a med reset.
Yeah, it was a med reset. I was sick yesterday.
This is Alton Kerr. So I'm thinking this was a med reset.
I don't have it in front of me.
It was recent from yesterday.
These are ad charges.
What's the unoccupied conveyance that they're alleging?
He broke into vehicles inside of Riverside Park, and there's 4 cars listed.
Did he actually get into them to actually get in?
Smashed rear window with the property taken from inside the vehicle, so I'm gonna go with yes.
Okay, no objection.
All right, as to counts 10, 11, 12, 13, 14, 15, and 16, the court finds probable cause on each one of those counts. His bond's gonna be $1,000. Kirby Telsine. Kirby Telsine. Do we know where Kirby is?
This is the one that I was talking about.
Oh, we can't do anything till we figure out where he is.
Your Honor, there are no deputies in the main jail anymore, so I couldn't tell you where they are. Maybe confinement status might know where he is.
Thank you very much. Telsine.
It says reset for attorney to appear, so that's me. There must be a perfection issue that we reset it for.
Med reset 716 for bond purposes.
Are you looking at a different, do I look below or do I look at above?
Below.
Below, okay, my mistake.
Well, first we gotta figure out where he is.
Your Honor, I have a note here for Mr. Telsine saying Division FY on July 20th at 8:30, so he may already have a date in 3 days.
It says he's housed in medical right now, so it's probably medical.
Okay, we're doing a medical reset. All right, medical reset for tomorrow. And that concludes the morning and afternoon docket.